Okay, so we now have a quorum and we will begin the Closing the Justice Gap Working Group meeting. This meeting is being recorded. Before I take roll, we ask that anyone who plans on giving public comment to use the raise hand function to indicate that you'd like to do so. Now, with permission of the chair, I'll take roll.
Yes, thank you.
Justice Tucker.
Here.
Mary Baldwin.
Here.
Becky Sandifer.
Present.
Marta Alkenbrock. Andrew Arruda.
Here.
Wendy Chang. David Engstrom.
Here.
Dan Grunfeld. Eric Helen.
Here.
Kathy Huang. Micah Star Liberty.
Here.
Kevin Moore.
Here.
Wendy Musell. Lucy Rica.
Here.
Toby Rothschild.
Here.
Patricia Scutiero. Patricia Scutiero. Sacha Steinberger. Betty Williams.
Here.
And Lori Zelon.
Here.
Thank you.
I believe Kathy has just shown up. If you want to recall her name.
Kathy Huang. No,
Here.
she's here on the chat.
Thank you.
Got it.
And Marta Alkenbrock is also present.
Okay, thank you.
All right, super. Thank you all. Ms. Lee, do we have any members of the public who have asked to provide public comment?
Once again, I'll make the announcement. If you'd like to give public comment, use the raise hand function. It does not look like we have anybody who would like to give public comment.
Okay, sounds like there's Can you hear me?
Yes.
Are there members of the public to give public?
No. Nobody has
Unstable.
indicated they'd like to give public comment.
My internet is unstable. Blame the State Bar internet. I apologize. Okay, well then we will move right on to announcements. And among those, I think I get to give the first one, which is to welcome our new members. We have 2 new members, both replacements for people who were no longer able to continue with us. The California Lawyers Association had originally sent us Tom Green, who made great contributions, but then had some additional obligations at work. I think I can take this off now. Some additional obligations at work that made it impossible for him to continue. So he resigned, and the California Lawyers Association appointed as his replacement Betty Williams, the controlling shareholder of Williams and Associates in Sacramento. Betty is a civil and criminal tax lawyer. She is the past chair of the Executive Committee of Taxation section of the State Bar. She is, perhaps most importantly for our current purposes, the Vice President of California Lawyers Association. And Betty, are there things you would like to add to that very brief introduction?
You know, not necessarily. I'm glad to be here and working with you guys on this. Tom Green did give me some background information. So I'm happy to answer any questions anyone might have, but I look forward to maybe meeting in person one day if we ever get to do that. But I see smiles, so that's good. I read everything that was sent to me and we had orientation this morning. So, you know, hopefully this won't be too much backfill for you guys.
That's excellent. I don't think we're going to do any backfill that won't be useful for absolutely all of us. And the second appointment I'm very pleased to announce is my colleague, Justice Lori Zelon, who after serving for a few years on the Superior Court, served for, was it 17 years, I think, on the Second District Court of Appeal. She's now retired from that job and serving intermittently on a pro tem basis on other courts. She was, before becoming a judge, a partner at Los Angeles's Hofstetler, Kaus and Ettinger, and then at Morrison and Forrester. She is a past president of the Los Angeles County Bar Association and past chair of many of its committees, including, most importantly for our purposes, its Access to Justice Committee. She is the founding chair of California's Commission on Access to Justice and a current co-chair of the National Justice for All Committee, and actually has a number of other past and future commitments in a similar vein. But I'm going to ask you, Lori, if there's anything you'd like to add to that brief introduction.
No, this morning I said that I was a bar junkie, and I guess I haven't reformed my ways. And I continue to be that, and I'm delighted to be part of this group.
Well, we are delighted to have you and to have you both. I know that you're meeting, the two of you are meeting all of us for the first time. So I'm going to ask everybody who is with us today to introduce themselves briefly. I'll start by just saying that I, as the chair of the group, I am a member of the First District Court of Appeal here in San Francisco. And I don't think I'll bore you with the backstory. But I am new to the issue that is the focus of our group, and have greatly enjoyed working with this group for the past year or so, and look forward to what we will accomplish in the next year or so. So how about our co-chairs? If Mary Baldwin and then Becky Sandifer would introduce themselves.
Justice
Sure.
Speaker, since there's so many people, why don't I just go down the list, the roll call list, and that way we can keep track of who's introduced themselves and who hasn't yet.
Okay.
Okay, so we'll have Mary next.
Okay, thanks. Welcome to our two new members. We're very happy to have you on board, and it's nice to see everybody else again too. I'm a shareholder at the law firm of Rogers, Joseph O'Donnell in San Francisco, and my practice focuses basically on attorney conduct, including ethics, legal malpractice, other matters like that. I'm the former chair of the State Bar's Committee on Professional Responsibility and Conduct, and I'm also the former president of the Bar Association of San Francisco and the Justice and Diversity Center. And I have a long background in pro bono advocacy and access. So that's me.
And next we'll have Becky Sandifer.
Hi, welcome to both of you. Lori, I think we've met a few times over the past. My name is Becky Sandifer. I'm on the faculty at Arizona State University and a faculty fellow at the American Bar Foundation. And my research area is access to justice.
And next we'll have Marta Alkenbrock.
Good afternoon. I'm Marta Alkenbrock. I'm a partner with Roby and Mathai in Los Angeles, California. I too am relatively new to this topic, although I've learned a lot working with this group. And I am my practice focuses on representing lawyers in malpractice, ethics, state bar proceedings, etc.
Next we'll have Andrew Aruda.
Hi there. I'm a technologist who's built on my second company now, advisor to many technology startups as well. In a previous life, I was also a licensed attorney out of Canada. I live in San Francisco, and I have been involved in this kind of topic for the past few years.
And then next, David Engstrom.
Hi, welcome to the new members. I'm David Engstrom. I am a professor at Stanford School, where I write and teach in civil procedure, administrative law and technology. And I'm also the co-director of the Deborah L. Rohde Center on the Legal Profession.
And next is Dan Grunfeld.
Hi, everybody. The video seems to be functioning, for which I apologize. I'm Dan Grunfeld. I am the former president CEO for a decade of public counsel. I will assume the chairpersonship of the organization in October. Former chief policy advisor to the mayor of LA, and served in management position in some big law firms. Been involved with these and related topics for more years than I would care to acknowledge.
And next we have Eric Helland.
My name is Eric Helland. I'm a professor of economics at Claremont McKenna College, and also an associate at the Rand Corporation's Institute for Civil Justice. And my primary research area is empirical law and economics, and in particular, the legal profession.
Kathy Huang.
from Los Angeles, and I am happy to be a part of this. I'm during the regular day, I am at the YMCA of Metropolitan Los Angeles, and I support our immigration integration work, our equity and inclusion work, and work with our Asian Pacific Islander communities. Thank you.
Next, we have Micah Star Liberty.
I am Micah Star Liberty. I have been a sexual assault, sexual abuse, and sex harassment plaintiff's attorney, trial lawyer for 20 years. I am a former vice president of the State Bar of California and a former president of the Consumer Attorneys of California, who appointed me to this seat.
And next we have Kevin Moore.
Greetings all. I'm Kevin Moore. I'm a professor at Western State College of Law in Irvine, California. I teach contracts, professional responsibility, law practice management, and remedies. And I've also been heavily involved with various and sundry committees of the State Bar and local bar associations with a focus on the rules of professional conduct and legal ethics.
And since we got Toby there with you, Toby, why don't you introduce yourself as well?
Okay, I'm Toby Rothschild. I'm currently of counsel to One Justice, doing ethics training and consulting for legal aid lawyers around the state. I've been basically a legal aid lawyer for something over 50 years and continue to do that as a volunteer since I retired a few years ago. And was on the co-vice chair of the ATLS task force that preceded this, and I've been on the Rules Revision Commission, COPRAC, and a couple of county bar ethics committees as well, the CLA ethics committee. So both ethics and legal services have been my forte.
Okay, and Lucy Rica.
Hi, my name is Lucy Rica. I am the Director of Policy and Programs at the Deborah L. Rohde Center on the Legal Profession at Stanford with David. I've also been involved as a member of the Utah Office of Legal Services Innovation and been heavily involved in this space for the past 4 or 5 years.
Next, we have our new members, Betty Williams.
Hi, I did already say hi.
Oh, sorry.
That's okay.
And then I guess I'll call on the Supreme Court staff. So let's start with Neil.
Yeah, hi, Neil Gupta from the California Supreme Court, where I'm the principal attorney. Been working at the court for the last 15 years.
And we have Greg Fortescue.
Hi, everyone. I'm Greg Fortescue. I am a lead attorney at the California Supreme Court. I've been working in this capacity for about 8.5 years.
And I don't know, should I introduce the rest of the State Bar staff that our new members may not have yet met?
I think our State Bar staff, starting with Leah Wilson, should say a quick hello.
Hi, Leah Wilson, the Executive Director of the State Bar.
Hi, Mia Ellis, Manager and Office of Chief Trial Counsel.
And I'm Bridget Grammy. I'm the Deputy Chief of Programs.
And I believe today we have Suzanne Grant with us representing OGC.
Yeah, hi, I'm Suzanne. I'm just, I'm temporarily in for another one of my colleagues. So if anyone has legal questions or issues that arise, I'm here during this meeting.
Great, thanks. I think we might be about to move to your presentation, in fact.
For the staff report, I did want to first call attention to the schedule of meetings. This is our return to work, and this is our first meeting, but we do have the schedule set for the remainder of 2022. It was posted with the material, so please add that to your calendar if you haven't already. We also have, at the leadership level, discussed and tentatively set the meeting dates for 2023. We are scheduled to complete our work and submit a recommendation in May of next year. And we're going to work a little bit more on that to get, together with the work plan and get those dates out once we are certain that they're finalized. The only other matter for the staff report is really that I invited the representative of the Office of General Counsel to give a brief sort of summary and status report on the Bagley-Keene requirements as they apply to committees of the state bar, particular committees that are meeting either virtually or in a hybrid capacity. And we did have one particular question to come up, which is with regard to what happens if you notice your location and then you have a last minute change of plans? What options, if any, do you have? But I'll let Suzanne give us a little bit of update. I think there's a statute also that we were hoping would go somewhere, but she can tell us more about that as well. Thanks, Suzanne.
So Randy, I don't have like a whole training prepared. I don't think that's necessary, right? Just like a general overview, right?
Yes.
Yeah, so during COVID, for the past couple of years, there were some loosening of the certain open meetings requirements, allowing for all remote meetings for state bodies, which meant that we could just use Zoom. And previously, and what is the law now, is you have to post an address where you're physically located. So that requirement was temporarily suspended for a couple of years. And just recently, a couple months ago, starting in April, the emergency requirements expired. And now we're back to having to comply with the traditional Bagley-Keene requirements, which does require the posting of a physical address. And that, you know, is a little burdensome because you have to, even though this meeting is remote, it's on Zoom, you do have to post your address. The address must be ADA compliant. So your question was, what happens if you have to switch addresses, right, Randy?
Yeah, we in fact, you know, had it even come up today, but.
Oh yeah. So, I mean, granted, we should all try to comply with Bagley-Keene's address posting requirement, but if you do have to, can't make that meeting at the notice location, you should let staff know right away. And I would say try to come to a notice location. Typically, I would think there usually is a state bar office available. And in which case you should try to, participate from that notice location. If that's not possible, technically, you're not allowed to participate at the meeting. However, you should ask staff. There might be a circumstance where you might be able to, and we'd look at that on a case-by-case basis. But as a general matter, to follow Bagley-Keene, you shouldn't be participating at a meeting that's not on the notice agenda. Does that cover it?
Does anybody have any questions about our Bagley-Keene requirements? Thanks, Suzanne. I think that completes our stuff.
Oh, I think someone had a question.
All right, if you're at a location that isn't compliant, should you fall off the call?
You can still listen in. There's absolutely no harm in that, but the idea would be, participating in the discussion and certainly not voting on something. But like I said, if there are circumstances arise, talk to staff. The standard is substantial compliance with Bagley-Keene. So, we might evaluate something on a case-by-case basis, but as a general matter, you should participate in a notice location.
Okay, so if today you are not at a noticed location, please, when your name is called on the roll, just say I cannot vote because I'm not at a noticed location.
In addition to that, I will say that going forward, since we will be continuing to have meetings in this fashion, you will receive an email from me asking you to fill out the Google Sheet with the location that you will be taking the meeting from. And if you don't provide it by the deadline, we cannot notice your location and therefore you will not be able to join the meeting. So please respond promptly to my request for your location going forward.
Okay, and in order to know whether an address meets the location requirement, it needs to be ADA compliant, and we need to be willing to allow a member of the public to come into the address and to participate, perhaps on her own laptop from that location. Is that the sort of the necessary minimum?
Yeah, so it's encouraged that they could see the laptop as well, but the statute requires at least audio access. So yeah, that is the requirement. They have to be allowed to participate in the meeting, meaning see what's going, hear what's going on is really the minimum.
Okay.
Micah has raised her hand.
Micah.
Yeah, I'm wondering if we don't get notice that someone is coming to our ADA compliant office building, for example, and can't tell security who they are, what's our obligation and how do we best serve the intent of Bagley-Keene if we're up in our office and security is not going to let anyone in with the pass upstairs, we have to give everyone, we have to give security everyone's name to even get access to our elevators.
Do you want me to answer that, Randy or Mimi?
Yes, please.
Yeah, sure. So I would say in that case, you should try to make it so that the security guard does let these people into the office or area where there is the meeting. Perhaps you could talk to the security guard and explain the situation and say that if people say they're going to be attending the meeting, they need to be let up. And if that's not possible, then that's probably not a place you should be having the meeting, because the public can't access it.
Okay. Any other questions about how to comply with our Bagley-Keene requirements? All right. The public continues to be able to participate just by calling in the way we all used to. So in practice, that's the most accessible form of public participation, right?
Yes. So we do, as we post the Zoom information, so we do make it publicly accessible. So ideally, the public could listen in, call in, watch remotely. But if they did choose to attend at one of the notice locations, they have to have that available to them as well.
Okay.
And if your location is not accessible, and when I send out the email asking for your address, please let us know if you would like to join from San Francisco or LA. We will reserve a room for you, just like we did for a couple of our members today, either at the LA office or the San Francisco office. But the earlier we know, the better, because there are a limited amount of conference rooms that we can reserve.
Okay. So I think Randy, you spoke to us, but didn't specifically introduce yourself when we were still doing introductions, and you're a vital member of this team. I don't know if there's anything you want to add in by way of introduction before we move to the next agenda item.
Just by way of introduction, the Office of Professional Competence is assigned to have primary staffing responsibility for administering the work of the working group, and I had some of our staff introduce themselves at the orientation session, but the primary folks you'll be working with is yours truly. I'm the program director for professional competence, and it's the office at the State Bar that deals with the rules. We have the ethics hotline, we have the ethics opinion committee, we have some other functions like lawyer referral services. The other staff persons who you'll be communicating with from time to time are Mimi Lee and Angela Marlowe. We are overseeing the Office of Professional Competence as part of the programs division of the State Bar, and the Deputy Chief of Programs is Bridget, and Bridget is also going to be overseeing, and she did introduce herself at the orientation, but I don't know if she wants to say another word here.
Sure, I'll just say briefly, I'm glad to be here again and to see all of you. I know most of you have already been working with me, but looking forward to just taking this group back, getting us back together and helping us work towards getting a final report. And just for the people and the new people, I don't think I mentioned that before I came to the bar. I was at the University of San Diego Law School at the Center for Public Interest Law for 7 years, and just working on these issues for several years also as part of the Access Through Innovation of Legal Services Task Force. And so it's a great area of interest to me, and I look forward to continue working with you all.
Thank you. And Angela and Lauren are off video, but we very much appreciate their very able administrative support for the entire task force. And with that, we should move, I think, to the next agenda item. Is there a motion with regard to approving the open session action summary from our December 1st meeting?
Move to approve.
Second.
Thank you, Kevin. Motion was made by Kevin, seconded by Toby. Any discussion?
All right. The first and the second having been made, any comment, discussion, or if not, let's move immediately to the vote.
Okay, Mary Baldwin,
Approve.
Becky Sandifer,
Approve.
Marta Alkenbrock,
Approve.
Andrew Ruda.
Abstain because I'm not in a right location.
Okay, Judge Wendy Chang, David Engstrom,
Approve.
Dan Grunfeld,
Approve.
Eric Helland,
Approve.
Kathy Huang, Micah Star Liberty,
Approve.
Kevin Moore,
Approve.
Wendy Mussel, Lucy Rica,
Approve.
Toby Rothschild,
Approve.
Patricia Scutiero, Sacha Steinberger, Betty Williams,
I'll abstain. I wasn't there.
and Lori Zelon.
Abstain, I was not there.
Thank you. Motion carries.
Excellent. Then let's move into our new business, starting with a presentation from Bridget, just briefly on the new and improved charter.
Thank you. Well, as you have in your meeting materials, so I won't go through it in detail, but as you all know, we had a hiatus over the last couple of months, and in that time have been working to streamline the work of the working group and kind of refocus us on what it is that we need to achieve by May 2023. And so the charter is organized in about 6 different sections. We have a section on just the assessment of the pros and cons of creating a sandbox. So these are all the different, basically these are all the different recommendations that will comprise our report and topics that will comprise our report and ultimate recommendations that we provide to the Board of Trustees about the sandbox. And so as it says in the charter, the whole goal is for us to be thinking about, or for this working group to be thinking about, balancing the dual goals of increasing access to legal services for Californians of all income levels, with the public protection, making sure that we are protecting the public and consumers in accessing those services. So those are the 2 goals that we need to be balancing as we're making these recommendations. And then there are 6 different topics would be just a general pros and cons about assessing what the sandbox should be, and then the structure, regulatory principles, just how, the overall arching guiding principles, the scope, the rules and laws, the consumer protection, and the consumer protection mechanism. So those are the 6 different topics that we have some specific things that we'll go through in more detail today with respect to just a refresher on what the group has already voted on as far as recommendations under certain parts of the charter, and then what items that we had been under discussion but hadn't completed. And then finally, we'll be kind of identifying certain areas that we need to continue to, we haven't actually had discussions on, that we will be thinking about and talking about this year before we finalize our report. So just wanted to give you that heads up that we've refined the charter a little bit. We've narrowed the scope of what we were supposed to be doing. There had been some other charges, as you may remember, to look at some other rule revisions, like the lawyer referral services were one of the things that we're looking at, the advertising rules. And since then, the Board of Trustees has given us the direction to just focus on the recommendations having to do with the sandbox and provide recommendations as they appear in this updated charter. So does anyone have any questions about that? I can't see any hands. Let's see. Okay, doesn't look like it. Oh, no, I don't think so. Okay.
I think we're good.
Okay, thank you, Bridget. So the one thing that's unchanged is that we are to come up with a proposal for a sandbox together with an assessment of the strengths and weaknesses of the proposal that we are making. But I'd like to open it up before we get into specifics. And just let, can we get rid of the paper? And yeah, thank you. And just let members of the group share any hopes and concerns, we might say, that you have as we restart our work. Are there things that are really important to you that you really hope we, if there's one thing we do, I hope it will be X. or concerns? The thing that's really bothering me is why? Are there questions? What I feel like we really need to know before I'm comfortable, making final recommendations is Z. I don't know. I'd like to give everybody a chance to weigh in on where you are as we restart our effort in terms of what your greatest hopes and concerns for our efforts are. Is there anybody who would like to start that off by sharing your thoughts? Marta.
I have a couple questions and that I've jotted down, but I'm just going to kind of shoot and we can engage in, I hope we can engage in a dialogue. First, I guess during the hiatus that we had, I know the Board of Trustees made some, based upon the work that the board did, the Board of Trustees made some recommendations and approved those, including the makeup of this group. And there's no easy way to say this other than I know the people that were on this committee that were not California specific were no longer here. And Becky, you do fantastic work, but I know you're based in Arizona. So I'm just curious as to how she's still a part of this committee.
Oh, that one I think is fairly easy to answer. And Becky, you probably would give it the best answer yourself. But I was involved in reviewing a brief. Basically, we asked each of the members of the group who could arguably not be California connected to tell us a little bit about what California connections they did or didn't have. And it was pretty readily apparent that while 3 people had commitments in this area of work, they did not have California connections, and that Becky has both California connections and commitments in this area of the work. And Becky, so that I don't mangle it, can you just tell us all briefly what some of your California connections are?
Sure. The 2 that are most closely related to this is that during the time I was on the faculty at Stanford, I was on one of the subcommittees of the state's Access to Justice Commission, the one focused on the right to counsel. And I did a fair amount of work with various people at the bar, helping them understand things they wanted to understand about what they were doing. And then, as many of you know, the state legislature a few years ago funded the Schreiber Right to Counsel pilot. And I was involved in advising all of the research that went into that. So I've sat on that advisory group now for about 6 years. Those are the things most relevant. Those are the California connections most relevant to this group's work.
That makes complete sense. Thank you for that. I appreciate it.
And Marty, you said you had a couple of questions, or maybe there's some other issues you want to raise?
Well, and then was a Board of Trustee member also to attend these meetings? That was my impression, that they were also going to attend.
So we have 2 ex officio members of our group who are both members of the Board of Trustees. And I can't remember both of their names, so I won't just mention the one I remember. But the 2 who have been added to our group are on all of our communications, and they are invited to all of our meetings, but they will make individual decisions about which meetings they actually attend. We hope to see lots of them, but we obviously don't see them each next. Does someone from State Bar staff have anything they want to add to that?
No, just to clarify, I think the 2 board members are Highland Chen and Mark Toney. And in addition to participating in the meetings as their schedules allow, we will be providing them, and Bridget, you can jump in if I'm wrong, I think quarterly updates on the project to include you, Justice Tucker, who may not have asked you that yet formally, but they will be briefed on the project at very time certain intervals.
Yes, nothing to add.
I'm sorry, what were their names again? My apologies.
Highland Chen and Mark Toney.
Got it.
Ms. Chen is a partner at Munger Tolles in Los Angeles. Mr. Toney is involved with me.
He's the executive director of Turn.
Thank you, executive director of Turn up here in the Bay Area.
And a public member.
Marta, did you?
Sorry, I was just clarifying, he's a public member.
Right.
I have a
Marta,
few
does that conclude your questions, hopes, and concerns, or is there more you'd like to share?
But your internet, Justice Tucker, is going in and out, just so you know. So we're getting some reverb. But I'll let Micah ask some questions, and if I have some others, I can do some follow-up.
Thanks. Just piggybacking on where we just were, is there any reason why the 2 ex officio members aren't on our roster? I think it would be helpful for the public to know that those Ms. Chen and Tony have been appointed or have volunteered or through the short straw, however you want to phrase it, but I think it would be important for them to be included on the roster. And then my question for now is this. With the old composition of the group, we had a lot of conversation, a lot of debate, and several votes. And so I'm wondering, are we now, with this new composition of this committee, going to go back and discuss certain topics or retake votes with the people who are now a part of the group and who are more appropriately positioned to vote on these very important issues?
So if I can jump in on that, first of all, I have to apologize to everybody for my lousy internet. I think I disappeared there briefly, and if it happens again, I would just ask Mary or Becky as our co-
So Justice Tucker, we seem to have lost you. So pursuant to your invitation, I'll just jump in. I mean, I guess one suggestion is I know that when my internet's unstable, I don't know if you go off video, if that will help strengthen your connection.
I'm trying that and hope it works.
You sound better.
Do I? Good.
Yep.
I will try to respond to Micah's question, if no one has already, by saying, yes, we definitely should have them on the roster. They were on the roster copy that I saw. If that's not part of our official roster, it seems like it ought to be. And your question about revoting, our intention in today's meeting, when we get just a little further along, is to go through what we had previously voted to approve as an entire working group. And then I have hoped to proceed sort of by way of consent agenda, have this group collectively vote that we are hopefully on board with what we've already decided, or to the extent we're on board with much but not all, to identify any piece of what we've previously voted for that we're not still in favor of. So as to things that had been decided by the CTJG, by the working group as a whole, yes, we do intend to resubmit those ideas to a vote, but we hope to do it as a single vote rather than piecemeal as a dozen or 15 or however many different items there were.
Okay, and so I'll just say for the record now, and obviously my voting will be consistent, the people who were on and no longer on should not have been able to participate, and I don't think those votes should stand. But thank you for answering my question.
Okay. Mike, are there any other hopes, concerns, questions you want to raise?
Not right now, but I'm sure there will be.
Okay, good. Thank you very much. Marty, your hand is raised again, or is that vestigial?
Yeah, no, I have another question.
Shoot.
One of our marching orders in this revised structure that we're in is that we're not going to be tasked with looking at rule revisions, as I understand it. And I'm just curious how we can contemplate or make recommendations with respect to a sandbox without rule revisions as contemplated in that work. So
let me answer that in a way that I hope will clarify. You may remember that our original marching orders were to make recommendations about a sandbox, and then also to make recommendations. I think there were 4 specific rules that we were asked to look at in a way that was sort of separate from the sandbox. In fact, it was specifically separate from the sandbox. So it's those 4 specific charges as to 4 specific rules that's been jettisoned from our charter. But everyone still, I believe, agrees and understands and accepts that no sandbox will happen unless and until a sandbox proposal is approved, first of all, by the State Bar Task Force, State Bar Board, who would then forward it for consideration to the legislature and the Supreme Court, and it would have to be approved in both of those places before it would happen. In the course of doing that, whether there would be a specific rule that would embody the recommendations of this group, or whether it would be a specific piece of legislation or a set of rules or whatever, that's not something the charter takes a position on. So in saying that we're no longer being asked to look at changes to the rules, that refers just to the 4 specific things we were asked to do. It's not saying that somehow we're not going to adopt the, if the sandbox proposal is ever adopted, that it wouldn't entail changes to the rules to say so. Does that answer your question?
Part of it. If we're not going to be making recommendations for rule changes, then is that up to the legislature to do, or who is going to be making those types of recommendations or decisions relative to rule changes?
Are you talking about rules changes to implement a sandbox proposal or some other kinds of rule changes?
To implement a sandbox.
So it would certainly be appropriate if we wanted to suggest rule changes to implement a sandbox for us to do that. That is not being excluded from the category of things we can or should do. And I believe that it's usually the State Bar and not the legislature that changes the rules of, the Supreme Court, after considering a proposal from the State Bar, that changes the State Bar rules. So that is certainly something we could make a recommendation on if this group wanted to. But it would just be in the context of the sandbox proposal, not those other requests for rule changes that were originally part of our charter.
Okay.
Other hopes or concerns? Other questions?
I guess I do have another one. I'm sorry, I don't mean to be taking up so much time, but I know that, are we gonna, I believe we're having a report on the paraprofessional program.
We are at the end of the day, yeah.
And I know the paraprofessional program did limit their kind of scope of services that were going to be offered by paraprofessionals to 2 areas. Is it the sandbox? For our work, are we likewise going to be limiting our the sandbox proposals to specific areas, for example, the UD and family law areas?
So now you are raising a question that I couldn't answer, because that's going to be something that this group is tasked with deciding. We will hear briefly from the paraprofessionals task force at the end of the day, because we had heard from them in an earlier time. And I wanted us all to be up to date on, now that the task force is finished with making their recommendations, what exactly is their recommendation? But obviously the 2 efforts are very different. And while there is some overlap in the sense that both are ways that the State Bar has begun to think about how things could be done differently in order to facilitate access to justice. I think, we are We are by definition a controlled experiment, and the exact scope of our experiment or of our sandbox is still very much to be determined. So if members of this group want to suggest a specific scope for the sandbox, that is hugely important and needs to happen sooner rather than later, but is still very much an open question. Relatedly, I will say that part of our new charter is that we're not functioning with subcommittees anymore. But that doesn't mean that we're not going to be looking to all of you to provide the grist for our mill, the ideas for our consideration, and the work behind the proposals for any particular proposal that we're going to undertake. So where members of the work group have specific ideas for things they think should be part of the sandbox proposal, we want to hear from you as to what you want to see in the proposal and why. Micah, your hand is raised. Where's that vestigial?
No, Marta bringing up the paraprofessional group raised something that I've been curious about and that folks around the state have raised with me as an area of concern. When the paraprofessional final report was in the public comment period, there was some messaging by the state bar that was advocating essentially the passage and kind of endorsing the concept in the final report before there was a vote on it. I'm curious as to what the state bar's plans are during this working group and if there's going to be similar kinds of advocacy before the Board of Trustees makes final votes.
Okay, I'm going to ask that question be put on hold until our 4 o'clock presentation, so that everybody can be on a little bit more even playing field and understanding where things stand with the paraprofessional task force. So we put that at the end of the agenda on purpose because it is somewhat different from what this group is focused on and doing. And while I think there may be some lessons learned pro or con from the experience of that other task force, I really don't want what they've done, what they are doing, what the state bar did with regard to them to distract us. So by all means, Micah, raise that again when we have both Leah Wilson and Justice Petrou with us after 4 o'clock. And we can at that point talk about any connections, parallels, or lack thereof between that group and this one.
Okay, I will do so. Thank you. To be clear, I wasn't asking about what the paraprofessional group did. I was asking about what the state bar did.
Right. No, I understand, but you're making you're trying to draw a parallel that I want to keep anything related to the paraprofessional task force for the separate conversation because it is a separate effort. And while I want us to learn from what that group has done, I don't want us to be distracted by it. But on the sandbox proposal that we're here to flesh out, to evaluate, to draw the contours of, who else would like to share any hopes or concerns or any thoughts about what we need to learn collectively, what research we need to find or to have done before we're ready to finalize the recommendation?
Justice Zucker, this is Randy. I don't know if it will help encourage anyone to speak, but I think one of the things that's also part of our continuing effort on the work plan is selecting presentations. And we did have a number of presentations before the hiatus. And I'd welcome the input from the committee members on any presentations that they felt would be helpful to them going forward.
That's a very good point. anyone wants to, either now, if you have some ideas, you're welcome to share them. If you come up with ideas after now, please do shoot them by email to Randy and others on the State Bar staff or to me. Okay. The one other piece that I wanted to bring into this discussion about our goals and objectives is a strategy for writing the report. I like to be focused on what is the end product and how are we going to get there. The end product here is a report that embodies the recommendations of at least a majority of the task force. Obviously, it would be lovely if we could reach consensus, but where consensus is not possible, we want to at least embody the recommendation of a majority. Where there's contention and there's a majority, but also a minority view, we would, of course, include a minority view comment, or I don't know exactly what to call it, but every member of the task force who wants to contribute to the report, whether or not he or she represents the majority view, is going to have a route for doing so. But we also thought, because it is difficult to write a report with 25 people contributing, that we should accept the offer of the State Bar staff to be drafters in chief of the report itself, with the understanding that we, the working group, as the authors and signatories, have final editorial control over whatever draft they come up with. And related to that, we have an opportunity at the front end to provide not text, but also research background, explanation for why this route is better than that route, or whatever, on the many decisions we need to make about what the proposal should be. So, as I mentioned a moment ago, I will still not only welcome, but sometimes twist to get white papers from you, in sometimes one of you, sometimes 2, 3, 4 of you at a time, on a topic. And if you have an idea of something you know is important that you want to prepare, please just let me know you have it in process, or you want to have it in process, and when you think you'll have it ready to share with the group. Any questions about that? Thoughts, comments? Any other comments or thoughts about our discussion before we head into the more nuts and bolts pieces of what we have already decided, and then after that, what we were on our way towards deciding, but hadn't yet reached a vote on before we broke at the end of last year? Okay, hearing none, I propose that we get started with agenda item C. I know it comes in multiple parts, and depending how quickly it goes, we may break before we finish agenda item C for our mid-afternoon break. And if not, we'll power all the way through agenda item C and take a break before we get to item D. So I think, Bridget, you are first up in running through the summary of the adopted recommendations. Before Bridget speaks, I'm going to just remind everybody that at the end of all of this, I will be asking for a motion to re-adopt the previously adopted recommendations as summarized in this discussion we're about to have. So, Bridget, you're on.
Thank you. So what we tried to do in this item C is break down the different recommendations that have been voted on by topic, just to kind of help frame this for everyone. And we summarized what the different recommendations were, but then provided links for the specific language down below, and then also links to the underlying memo where possible, so that you can all have all the background if you need it. So I'm just going to stick to kind of the higher level principles. And in my case, I'm going to cover the general principles that don't really fit under a particular topic, but are just kind of overarching principles that apply to the entire recommendations about the sandbox. So the first one that the group voted on was that, and this was towards the end of our time together, I believe this was at the December meeting, that the sandbox should be established only if authorized by both the Supreme Court and the legislature. This would be a recommendation from the working group to the Board of Trustees. And so this is, anyway, that was something that is kind of solidifying the working group's messaging and intent that this is not meant to go around anybody, but we would be making this recommendation, and then both the court and the legislature would have its say in approving it. And then the second general principle has to do with the key function of any sandbox is to collect targeted evidence to inform decisions about legal services regulation policies, while balancing the need for data collection with a potential burden on participating entities. And there are really three different recommendations that support this general concept, but the idea is, as Justice Tucker talked about, and Randy even in setting this up, is that the sandbox, the whole point is like someone referenced, like a controlled experiment. We're trying to see what would happen if things change, but also make sure that we're monitoring and collecting evidence so that we can assess at the end of the day whether ultimately these rules should be changed. And so ways to do that, how to collect the evidence, and also recognizing that for some groups, such as nonprofits or other organizations, might not be robust enough or be collecting a ton of data about their clients. And so we want to be, balance the need for the data with the burden that it would be placing on applicants to the sandbox, because we don't want to discourage people from applying in the first place. So these are, again, just kind of bigger principles. And then, there's more details set forth in the recommendations about the types of questions that we want to be answering and the types of data that we should be gathering to support those. And then the final general principle has to do with funding. So generally speaking, we want to make sure that there's funding to support the data and the evaluation, and independent evaluation, so that the decision makers, the ultimate decision makers, can be confident in the data that has been collected and analyzed, and to inform the ultimate decision about whether or not the rules or laws that are being tested in the sandbox should be changed. And this, again, these recommendations 3, 12, and 14 have to do with the types of, again, the same types of questions that should be answered and analyzed when assessing whether or not this experiment is making an impact in a positive way on consumers. And setting forth some irregular intervals for which this independent evaluation should take place. So that's a brief overview of the general principles. Does anyone have any questions or want me to go into more detail about those recommendations?
All right, I think we can move on to Mary then.
Okay, thank you. The next section, I'm just going to talk a little bit about the recommendations that we adopted concerning the structure of the sandbox. And this came out of the SAGE committee that many of you were a part of. After considering a number of different options for how a sandbox could be structured within our system, we recommended that the sandbox should be governed and administered by a regulator, which would be established by the legislature within the judicial branch of government, and which would serve as an arm of the California Supreme Court, and is basically a sister agency to the state bar. And we considered a lot of different options, and ultimately decided that was the one that made the most sense for a lot of different reasons. And if you look at our resolutions in the attached here, you'll see the recommendations 2 and 4 lay this out. And 4 in particular talks about how the regulator would be subject to review by the Supreme Court and how that would function. And then also talks a little bit about shared responsibility with the legislature, and ultimately clarifies the last sentence that none of the foregoing is meant to alter the roles of the Supreme Court vis-a-vis the legislature, and that was the subject of a lot of discussion. then we also looked at some of the more specific aspects of the structure, how the regulator itself would be governed. And we recommended that there be a volunteer board with responsibility for all operations, as well as a staff. And there was some discussion that did not make it into the recommendation, but about how whether the state bar, for example, could provide some of those staff functions. But the recommendation itself just says that there shall be a staff. And then specifically with regard to the board, recommendation 6 provided a very specific recommendation concerning how many board members, how they should be appointed, who should be appointing them, and what their backgrounds should be. And I think that is pretty much the structure recommendations that we adopted. Okay, looks like Justice Tucker's getting help.
I am, but I'm back enough to say thank you. And the next segment is Randy's.
Thank you, Justice Tucker. Topically, I'm going to be addressing a couple of recommendations that fall under the heading of eligibility to be a participant in the sandbox.
Randy, sorry, real quick. I see that Micah has her hand up.
Sorry.
Thank you so much. I just was wondering if we could, just to help the new members get up to speed, list what the vote was, because I want the new folks to understand that these are not unanimous votes, and there was some dialogue about this. So I think it would be helpful.
Micah, I think that information is included in the table that was distributed in the memo. So for example, from Mimi Lee, May 26, subject 2C, it has on the left-hand margin what the vote was on every single one of the recommendations.
That's correct. So if you, for example, you're, if you want, I could even just show you right now. Hold on one second.
Yeah, that would be helpful. I'm using a State Bar computer that's not exactly easy for me to change the interface.
Oh, well, this is the agenda item that was posted. And so if you were to click on any one of the recommendations, it tells you what the date of the meeting is, and you can click here and go to the agenda materials, or it tells you the vote right below it. And this is all posted and circulated ahead of time. So, and I did state that, I think in the email, that if you were on the front cover of this agenda item, it explains that if you click on any of the links, it'll take you to the agenda materials from that day. So you could get the background materials on any one of these recommendations as well.
Right, I'm just saying it's a short, we're getting a short description, and I think it would be helpful rather than people stop, they're listening and start clicking. If it's available and people can just say what the vote was, I think that would be helpful. Just a suggestion.
So it is available. It is available through the materials that were sent. If there's any particular item that you think needs to be called out at some point, by all means, raise hand and call out on that specific item. But Mimi is showing us here a vote of 15 to 1501 on recommendation 15, for example. Thank you. Randy, do you want to talk about the eligibility points?
I will. The first one is pretty straightforward. The working group at its meeting on August 11th was item 2G that originated with the scope subcommittee, and the principal authors were Toby Rothschild and Andrew Tuff. And just as a footnote, Andrew Tuff has moved on from the Office of Professional Competence, so he is not currently supporting the work of the committee. But this particular resolution stated that disbarred, suspended, resigned, or involuntarily inactive lawyers from any jurisdiction should be ineligible to participate in the sandbox. And the entire working group received this recommendation at that August 11th meeting, and the vote to adopt it was 18-0-0. I have recorded here. And just for some background, the concept of allowing disbarred attorneys to become providers of legal services in the experimental context of the sandbox was not controversial with respect to this recommendation. However, we greatly value the input of Toby and Andrew in clarifying that if you compare with the existing rule of professional conduct, Rule 5.3.1, that restricts the relationships between licensed lawyers in the practice of law and certain attorneys, including disbarred attorneys, that category of ineligible persons was broader than simply disbarred attorneys. It include attorneys who were actively on suspension, attorneys who resigned with charges pending, attorneys who have been enrolled involuntarily inactive, and that those attorneys should also be subject in a sort of a scope context from being participants in the sandbox as a provider. In one sense, if the sandbox were to seek to allow these ineligible practitioners to render legal services, it would be obviating the entire, reinstatement process that is available to a disbarred attorney. And there are involuntarily inactive attorneys who, while they may not have engaged in misconduct, have certain characteristics that would make them inappropriate as sandbox providers. And I'll mention just one. Under the State Bar Act Business and Professions Code, Section 6007, the state bar is required to enroll an attorney as an involuntary inactive licensee if that licensee claims insanity or mental incompetence in a legal proceeding. And so these are all persons that the working group determined, as a matter, again, of scope perhaps, that should not be the folks who we want to base our data on or to engage in experimental, innovative delivery of legal services. And again, it was a strong consensus. The other one I have to present came out of the working group's meeting on October 18, 2021. It was item 2A and originated with the then SAGE subcommittee. And it was on the topic of recommendations for risk-based regulation, the principles with regard to the regulation of harms to consumers. And this one was by a vote of 13-4-0. And it really came out of a discussion of another recommendation. So one of the recommendations for the principles of risk management, risk-based regulation, was the idea that for purposes of admission to the sandbox, the risk of harm to consumers should be measured relative to the experience that the consumer would have had absent the legal services provided. And so I won't get into this because there's another speaker who will speak to this, but the idea was a juxtaposition, not of how would this consumer fare vis-a-vis having a full service law firm at their disposal. It was really how would they fare if they had no services whatsoever. But the issue that came up, and this is one of those recommendations that was not memorialized in the actual subcommittee memorandum because it was developed at the time of the working group meeting. The point that was raised was there shouldn't be an implication that anything is better than nothing, because the anything, those legal services, might be incompetent or cause more harm than good. So a principle that came out of that discussion was really a broad-based, and I'll call it eligibility, that's the topic put under, but that applicants must demonstrate the capacity to provide competent legal services. And so while we do want to look at, again, that juxtaposition between not having any services at all, there is this other equally overarching principle and would constrain the ability to participate as a provider in the sandbox, that there has to be a demonstrative capacity to provide competent legal services. And that would be part of the application process, whether the systems they have in place, maybe they have a compliance attorney to vouch for the competence of the legal services. But that is the other recommendation on eligibility, again, 13-4-0. And those are the two that I have.
I had a question, if I might.
Please.
This is Kevin down in Irvine.
Sure.
Okay. On the table, the first table under eligibility, if you could go back there. And I'm being a little bit picky about how it's presented. You say disbarred, suspended, resigned, or involuntary and active lawyers should be ineligible. I thought the vote stated they must be precluded. I mean, we're not just saying this is our our recommendation as to how to set up, if you look at structure. I can see why you use the word should be. The aspirational, we should have a separate organization, regulatory authority that's going to be supervising the sandbox. I understand that, because that's going to depend on a lot of factors. But our vote was that they are ineligible. We simply do not allow them, and I think that should be reflected in the table, that they must be precluded. We're not just saying they should be, we're saying they must be precluded. That was a fairly strong sentiment on the part. That was a real consensus sentiment, I think, among the people when we voted on that. And if you look at the next item under eligibility, we talk about must. So, it's my old rule drafting experience. Should is aspirational. And I wanted to say this is mandatory. We want to send that message that it's mandatory. Thank you.
So let me just respond to that by saying the articulation, the wordsmithing was not consistent in terms of how the statements were being presented. What is anticipated is that all of these statements will be recommendations of the working group. And so the recommendation of the working group is that disbarred, suspended, resigned, or involuntarily inactive lawyers from any jurisdiction must be ineligible to participate in the sandbox. And so I think when we pair it with what will be a uniform presentation of these statements as a recommendation, that you can go to the must. But I think at the time when we were just putting these up for the vote, the should be is very much reflective of really the modest posture that the working group is in, which is not a policymaker. We can't determine that it is a must, but we can recommend that it should be a must. And so I think when we do final editing for consistency, that these statements will all be framed as recommendations, strong recommendations of the working group.
I guess I would want to say we recommend that they must be ineligible.
Oh, definitely.
You should be. Thank you.
I think that's correct. I see Justice Elon's hand up. I think you're on mute. Oops. I think you're still on, Justice Elon, I think you're still on mute.
Sorry.
Thank you.
I had a question about the capacity and competency issue. It is one thing to have someone demonstrate that they have capacity, but it is another thing to require that they use that capacity and that they not, for example, understaff or under-resource the delivery. And I think, without having been privy to the discussion, of course, just saying that they must demonstrate the capacity leaves a lot of questions unanswered.
I think that's a good point. In fact, our California Rule of Professional Conduct on competence is about utilizing competence as opposed to merely possessing it. So it very much tracks our legal ethics jurisprudence in California. I think what's at work here, however, is the fact that this was really just a broad principle that was to clarify another principle of the sandbox, which is again that juxtaposition of the risk of harm to consumers if they receive no legal services. What remains and is a to be determined issue are the rules that would be subject to modification or waiver in the sandbox. That is a topic that has not yet been discussed. I'm going to be presenting on a couple that came up in connection with data privacy and confidentiality. But other than those provisions, this group has yet to decide whether there'd be any sort of diminution of the rule of competence in California for any sandbox provider. That is a topic to be determined.
Thank you.
Okay, I do have some that come under the category of conduct. I'm going to go.
Hold on, I see Eric had his hand up still, sorry.
Oh, go ahead. I can't see everybody's hand.
Sorry about that. I was just going to speak to the comment that was just made by Judge Zealand, that I think we were envisioning this, that the risk management, the part of the ongoing evaluation, would be the part where you evaluate whether people were using that capacity. So we hadn't made any recommendations on that, but I think the thinking at the time of that recommendation was there was an initial demonstration. Could you do what you were saying you were going to do? How you actually implemented that, whether you put the resources behind it to do it, was part of the ongoing evaluation. And I think the feeling, although again, we hadn't made any recommendations on this, was it might be very difficult to determine going forward if someone could put the resources in place to do what they were saying, but that it might be possible to see if they actually had the capacity to say, produce a document or something like that. So I throw that out there as something I'm sure we'll discuss more later, but just kind of as a bit of background information, because it's a really good question and one we had kind of wrestled with previously.
Okay, the next one that I have comes out of the CTJG meetings where we were discussing some technology related issues. And these stem primarily from considerations of data security and privacy. And these were presented primarily from the Scope Subcommittee. David is on the line and can also hopefully back me up on these. But these were at the time denominated as recommendations 7 and 8, and they pertain to whether or not the participants in the sandbox would be held to certain standards of data privacy, confidentiality, and privilege. And just to back up to the 1,000-foot level, in the sandbox, the experimental aspect of it is that there might be current rules or requirements that apply generally, but might be modified in the sandbox. And so on the issue of lawyer participants, the initial discussion by the working group was that if a lawyer seeks to be a provider and entrant into the sandbox, then they would have essentially their duties that they would normally have follow them into the sandbox. And in particular, the protections of the attorney-client privilege should extend to communications between clients and sandbox providers, that the duty of competence with regard to competence in technology used in the practice of law, the duty in the rules 1.6 concerning confidentiality, which is actually part and parcel of a statutory duty of confidentiality in 606A subdivision E, and the other rules of professional conduct that implicate this duty of confidentiality, use of confidential information under Rule 1.8.2, duties to former clients and prospective clients, respectively, Rules 1.8, 1.9, and 1.18. And finally, the California Consumer Privacy Act, that all of these things, as they apply to lawyers outside of the sandbox, should apply to them inside of the sandbox. And if you are a non-lawyer subject to, for example, the California Consumer Privacy Act, then you would also carry that with you into the sandbox. And the rationale largely of this approach, because the working group could have decided that we will have our own clean slate and we will write our own rules of confidence, our own rules of data privacy, our own rules of privileged communications. But what the working group agreed with from the scope presenters was the idea that these standards are evolving. They are laws. They are rules that are subject to interpretation. If you're talking about rules of professional conduct, interpretation by the state bar court, interpretation and ethics opinions. Similarly, the statutory provisions of the attorney-client privilege and the statutory duty of confidentiality of 606AD are subject to possible amendment as well as interpretation, and even the Consumer Privacy Act, which presently applies to only large entities, might be subject to change. And so rather than have a situation down the road where we have articulated certain standards for the sandbox, and then outside of the sandbox, there are changes to these standards, I think the expression used was that the sandbox should hitch its wagon to these existing laws as they then apply, so that if there are changes, because the sandbox will run 2, 3, 5 years, who knows what the term will be, we haven't determined that yet, then those standards will be consistent as they evolve. And there was recommendation 7 that largely encompassed that. And then recommendation 8 was referred to as a leveling up of the attorney-client privilege, because the attorney-client privilege as a statutory construct applies to communications between a lawyer and a client or a prospective client. But that would not encompass a provider in the sandbox who was not a lawyer. And we do have precedent in the statutory provisions for extending a privilege similar to the attorney-client privilege to non-attorneys. And so in the evidence code, as precedent, is a provision that extends the attorney-client privilege to communications with a certified lawyer referral service. And we have adopted this recommendation that the legislature extend the protections of the attorney-client privilege to communications between clients and sandbox participants to do something similar. And that one also was not viewed as controversial. It was passed on a vote of 14-0-0. And so for the non-lawyer providers in the sandbox, the expectation is that the sandbox would want appropriate regulators, in this case, the legislature, to create a privilege to impose that same protection in the sandbox for those providers who aren't otherwise already governed by the attorney-client privilege. And that's those provisions. And if there are wording issues, I think this one starts with recommend that. So I think hopefully that takes care of the shalls or must issue.
I have a question.
Betty, yes. Please.
Hi, on recommendation number 7, the last sentence talks about participants ordinarily under the California Consumer Privacy Act would still be under the CCPA. Is that distinguishing it from being under the other rules, or is it saying they must be in compliance with both?
It's all.
All, okay. Thanks.
Are there other questions before we moved on to Becky's segment on risk-based regulation? Becky, you're up.
Great, thank you. So the full group voted to recommend that the focus of regulation in the sandbox would be consumer protection, and that the way in which that would be pursued would be based on risk to consumers of actual harm through the proactive collection of evidence about the actual experiences of consumers. So that's basically recommendation 16, which passed unanimously when we voted on it back earlier in the year. Then we discussed what the risks or the potential harms would be that the sandbox would be looking for. So those are receiving an inaccurate or inappropriate legal service, getting bad advice or incompetent information that leads you to make a bad legal choice and fail to exercise a right, buying something you don't need or paying a really inappropriate amount for it, and then being the object of fraud, theft, loss of privacy, or abuse of trust. So those four were recommended by the group 14-2. And the other aspect of our discussion that the staff have included in this sort of summary is recommendation 10A, which I think Randy already discussed. It's the idea that when you're thinking about the standard to which the consumer's experience will be compared, it is the consumer's actual experience right now, which is in 80 or 90% of cases, they receive no service from a legally competent person, right? From somebody with some kind of legal training. So we should compare the sandbox experience of consumers to that experience of consumers. And that was recommended by the group 13-4.
Are there questions or comments on the thoughts that Becky has shared? Are there questions or comments more generally on anything from agenda item 2C? Or is there a motion? And to be specific, I'm hoping that somebody will want to make a motion that the working group, I haven't written it, but something along the lines that the working group continues to accept and recommend what we've accepted and recommended by the past votes that have been summarized just now.
This is Eric Helen. I'll make that motion.
Okay, great. Eric, I saw that Lori has just put a hand up, so let's hear from Lori. I guess now that we have a motion, we need to ask for a second, and then we should hear from Lori. Oh, yes. And now her hand has disappeared. Lori, was that vestigial, or do you have a question?
My hand is down now.
Ah, got it. Okay.
I'm go on without it.
Okay. So Eric has made a motion. Is there a second for the motion?
Justice Duker, I'll second the motion.
David has seconded the motion. Mimi, do you think you have the motion captured, or do we need to recapture it?
No, I have that the motion was made by Eric and seconded by David, and the motion is that the working group continues to accept and recommend what was previously approved by the working group.
Okay. Any discussion on that? Micah?
I think that a more appropriate motion would be any vote that was unanimous, we can affirm, and any vote that was not, where there were votes against, we should reconsider and evaluate as currently constituted.
So you would like this motion to go just to the recommendations that were previously unanimous?
Yeah, I mean, I'm not expecting anyone to accept my request for an amendment. I'm just stating what I think is appropriate.
Come on, and if you're making it, you should expect the possibility of success.
Well,
so Micah would like us to vote separately on the things that were unanimous and the things that were not. Is that an acceptable, friendly amendment to Eric? So in other words, this would be a motion to adopt those items that were unanimously agreed to by the working group, and then we would separately go through the things that were not unanimous.
Since it was my motion, Justice Tucker, I'm just going to confirm Micah's suspicions and say that, no, I don't accept that as a friend, as a friendly amendment.
Okay,
Cal Surprise.
okay. Then any other discussion before we call the motion? Hearing none, I would ask Mimi that you call through the motion, call
Okay.
through the roster.
All right, Mary Baldwin,
Aye.
Becky Sandifer,
Aye.
Marta Alkenbrock,
Aye.
Andrew Aruda, Wendy Chang, David Engstrom,
Aye.
Dan Grunfeld,
Aye.
Eric Helland,
Aye.
Kathy Huang,
Aye.
Micah Star Liberty,
No.
Kevin Moore,
Yes.
Wendy Musell, Lucy Rica,
Aye.
Toby Rothschild,
Aye.
Patricia Scutiero, Sacha Steinberger, Betty Williams,
Yes.
and Lori Zelon.
Aye.
Thank you. The motion carries.
Okay, I think that is a good place for us to take our mid-afternoon break. Why don't we come back in, I guess it would be 8 minutes at 2:45 to do agenda item 1D, and then, sorry, it would be 2D. In any event, to carry on in 7 or 8 minutes. See everybody soon. Bye. Thank you, Mimi. So this next agenda item has been noticed just as a report, not as an action item. So if, as you follow along, you see things you think would be worth us all voting in favor of, you're certainly welcome to express that view. But mostly, we're here to be reminded of the work that we were in the middle of and the discussions we had not yet resolved, so that they can inform decisions that we will make in the future. Because if you tell us today, gosh, that seems like something we sure could vote to approve, I will make a mental note of that, but we will not be entertaining any motions or holding any votes. We're just going to be discussing the report we're about to receive. So with that framing, can I ask our presenters, starting I think with you, Randy, to go ahead and walk us through some of the things we were working on but had not yet resolved.
So one of the things that the working group was considering, and this was primarily through the then SAGE subcommittee, was the broad topic of risk-based regulatory approach to regulation. And again, just at the 1,000-foot level, one of the things that is the whole purpose of a sandbox is to gather data on possible changes or exemptions to existing rules governing the practice of law, to see how they impact innovative delivery systems, the risks and benefits of those delivery systems. And what that presupposes is that in the sandbox, you are governed by certain things, and that as an applicant to participate, that you would be seeking some special dispensation to provide things in the sandbox that would be ordinarily not allowed outside of the sandbox. And before the break, I spoke about a very narrow topic that was sort of focused on, which is data security, data privacy. And because that is essentially a subset of information obtained in the course of an attorney-client relationship, we also took on confidentiality and privilege. And with that one, which did get up to the full working group, it was determined by strong consensus that those are things we must have in the sandbox, must have that confidentiality, must have that privilege, data security. And as I said, we're hitching our wagon to the existing law. And so that will track perfectly in terms going forward that participants in the sandbox, consumers in the sandbox would be the beneficiaries of those protections, just as if they were receiving services outside of the sandbox. No changes for those issues. But that leaves the entire body of lawyer conduct rules and other regulations of the practice of law unaddressed if they don't pertain to technology or data security or privacy or privilege. And so these resolutions that you're looking at on the screen now were discussed at the SAGE level, and they represent two key thought processes. One pertains to lawyers. Lawyers participating in sandbox entities should remain subject to the same rules and laws governing other licensees of the state bar, except to the extent that compliance with the specified rules is waived as a condition of entry into the sandbox. And so there could be the concept of a sandbox that is completely wide open, that is a blank slate, that the regulator and the provider will work together on the provider's proposal and decide, well, given your proposed innovative delivery system, here are the only things you have to worry about complying with. And that could be a very valid sandbox experiment to conduct. This recommendation describes a very different sandbox. It describes one where the baseline for lawyers in the sandbox is that they must remain subject to their existing rules, their rules of professional conduct, the duties in the State Bar Act, other provisions regulating their conduct, the rules of court, unless they are actually seeking to have changes to those requirements made, and that the regulator agrees and imposes relevant, adequate, customized, risk-based regulation protections, auditing, monitoring, all of that. And that when recommended to the oversight body, let's say the Supreme Court, legislature, et cetera, that is actually approved. And so this is very much a foundational, a critical concept of our development, our standing up of a sandbox, that lawyers who are in the sandbox all have the same baseline starting point, which is you are obliged to comply with your existing rules and laws. The companion to this one, and it's on the screen as Regulation B, is described as a leveling up, because our sandbox is going to be hopefully attracting not just lawyer participants, but others who have innovative ideas, technology-driven delivery systems, et cetera, so that we can, again, have that as part of our experiment, gather the data to see how those services can impact access, can serve legal services consumers. But if they are not already subject to rules of professional conduct, this recommendation would provide that entities participating in the sandbox should be subject to the rules and laws governing licensees of the state bar, again, except to the extent specified rules are waived as a contention of entry into the sandbox. And so this is not unprecedented. We have licensees of the state bar, registered foreign legal consultants, for example, out-of-state legal services attorneys, out-of-state general counsel. All of these folks, they might be bound by other rules where their home jurisdiction is, but if they come to California and want to participate, again, example, foreign legal consultant, then they have to agree to be bound and comply with our California standards governing our California lawyers. And that is the principle of this second recommendation, recommendation 8. It is a quote unquote leveling up of the standards of attorneys to all of the entities who might be participating in the sandbox, even though they might be a profit or nonprofit corporation, and maybe they have an in-house counsel or outside in-house counsel, or maybe even a compliance lawyer, but the entity itself would be subject to the standards and rules governing licensees of the state bar. They would have to level up and meet the standards of lawyers, our conflicts of interest standards, our fee division standards, our competent delivery of legal services standards, unless in considering their application and getting that approved by the oversight body, those things are actually modified or waived. Now, what did come up, and this did actually get discussed at a CTJG meeting, it was discussed at the October 18th meeting, but we did not take a vote, even though it came to us from the subcommittee at the time, was the concern that both of these recommendations refer to the whole concept of waiving or changing these standards. I don't think it was controversial that lawyers entering the sandbox must continue to remain subject to their rules, and that we should level up entities who are not lawyers to also be subject to these rules. But what was zeroed in on by some members of the working group was this idea of, but we haven't fully discussed how these waivers will actually be granted. And so there was an additional recommendation developed that wasn't in the materials at the subcommittee level, stating that the working group will separately consider the scope and mechanism of possible rule and statutory waivers. And so the other two recommendations, A and B, were not intending to assume facts not in evidence. It was supposed to say that everybody knew exactly how that process would work, but that there would be a process, and that the more foundational issue was we want lawyers to comply and remain compliant unless they get something waived. We also want entities that are not lawyers to comply, but in full recognition of the fact that the whole process for a waiver had not been developed, this third recommendation that it will be separately considered was adopted by the subcommittee to make sure that the other two recommendations are not misunderstood, or there's not an overstatement of what is actually being contemplated. What we want is the key aspect that lawyers remain subject to the rules, that entities entering in are leveled up and also have to abide by these rules, with an acknowledgement that the mechanism for any waiver that might happen in the sandbox is a proviso for these particular recommendations. And I did mention at the time that there is precedent for entities as opposed to natural persons being subject to rules. The Business and Professions Code section 6167 says that a law corporation certified by the state bar must comply with the standards of lawyers. Lawyer referral services are also regulated by the state bar. You cannot engage in a lawyer referral activity unless you meet the minimum standards and are certified by the state bar. There's a lawyer referral service rule, rule 3.829, that specifically says a lawyer referral service must comply with lawyer advertising rules that are imposed on lawyers. And so the concept of leveling up to have entities who might not otherwise be subject as a natural person to these rules does have precedent in those provisions. And that's all I have on those recommendations. Again, not adopted yet by CPJG, but were discussed at a meeting and were proposed by a subcommittee.
Randy? Okay, now you're off mute. Thank you, Randy. Mary, I think you have some risk assessment process comments.
Okay, so let's move to the next area that's on our agenda, and this is a very substantive group of recommendations that were discussed and not voted on. And pursuant to Justice Tucker's recommendation at the start of this discussion, I've been thinking about what in this group of previously discussed recommendations might be ripe for passing. I don't think this group is, because this, to me, among the provisions, the recommendations that I'm discussing here, these kind of go to the really heart of how a sandbox would function and how it would work to protect consumers. And I think we need to spend some more time. And I would recommend that everybody look closely at the memo that was attached to the materials dated November 24th, 2021 to the working group prepared by Bridget, because this really sets forth these recommendations. And I'll summarize them, but the summary doesn't do justice, I think, to the detail of the recommendation that we were working on when we stopped meeting as a working group. So I'll just, as an observation, just note that what this set of recommendations is intended to do is to try to set forth a type of regulation that is different than what we currently have. And what we currently have, you can think of as a reactive type of regulation. If somebody breaches a regulation, fails to comply with a regulation, then they are punished. A proactive type of regulation tries to anticipate what problems might exist and tries to put in place means of preventing problems from happening in the first place. And not to say that the sandbox would not include both proactive and reactive tools. We did start to discuss the possibility of reactive tools as well, but the initial focus here was on what proactive tools could a regulator implement in order to try to prevent harm from happening. And I'm juggling here between a lot of papers. I've got the memo in front of me, and then I've got our summary that's in the agenda. So I'm going to try to do this in a way that's efficient and not spend too much time talking about this, because again, I do recommend that everybody look at this, because this is really important to how the sandbox would function. But basically, the central focus of this risk assessment process is the formation by the regulator of an approach to assessing risk. And we had proposed a table, a risk assessment. I'm going to call it a table. I don't know, Eric, you might call it something different. I don't really know the difference between a table and a chart, for example, but it is a table with 2 axes. It was Appendix 1 to the report. And it basically attempts to calculate the amount of risk based on the extent to which a service might deviate from the way that traditional legal services are provided. And generally speaking, the risk assessment table recognizes that there is more risk the further away from a traditional legal service provider that a sandbox participant might be. So, and then the risk assessment, the risk model, regulation model, then imposes more obligations on the organizations or the participants with higher risk. So well, let me hold that thought for a minute. I'm going to go back to the process, because this dovetails to something Randy was just talking about. So the applicant would submit details about the proposed service. The regulator would assess the risk to be, that would be provided by that, or the risk that service would present. For the proposals that the regulator would recommend being adopted, the regulator would prepare a detailed summary document, which would go to the Supreme Court. This is all laid out in this memo. The Supreme Court then would evaluate this, including, and among the information that would be provided to the Supreme Court by the regulator would be, of course, details about the provider and the service, but also the reasons why the applicant cannot operate under existing rules, as well as the risk assessment. And then the document from the regulator to the Supreme Court would contain a specific recommendation, which would include the scope of the permitted practice, quality assurance mechanisms, term of authorization, etc. The Supreme Court then would take this summary and would decide which applicants to authorize, and would issue a detailed authorization order. And this authorization order is kind of the governing document that would apply to each sandbox participant. And it would list what that participant's allowed to do. It would identify the specific rules and laws that would be waived for that participant. So this dovetails to what Randy was just talking about, and other specific disclosures. And this authorization order, as it's framed in the recommendation, would then be something that the regulator would use, obviously, to define the scope of what the sandbox participant to do. It would be able to do. It would be publicly disclosed very prominently, because members of the public would look to that to understand what a particular service is allowed to do and what the framework is. For those sandbox participants that would be approved, there would be regular reporting and monitoring. This would be a very active regulation model, where there would be frequent and extensive reporting from the participant. Again, going back to the risk assessment model, the more risk, the more reporting that would be required. And we laid out, I say we, this was the SAGE committee, we laid out some pretty specific recommendations in that regard. There would be regular audits that the regulator would do to try to make sure that participants are actually complying with their obligations. And then there'd be, of course, as part of this, and this goes to the heart of the sandbox model, the regulator would be collecting data and the participant would be instructed as to what type of data to be provided. The recommendation goes on to then elaborate this consumer disclosures, because in a very important, recognizing that consumer protection is central to all of this, what type of information has to be provided to the consumer, and that would be including digital badges, other specific disclosure requirements that participants would have to make in various contexts on their website, elsewhere. And then we also discussed additional security measures that the regulator could implement, including security, a mechanism for reimbursing clients who are harmed, a secret shopper program whereby the regulator would go in, it's a type of audit really, robust consumer complaint mechanisms, and then consumer satisfaction surveys to try to monitor on an ongoing basis the experience of clients within the sandbox, as clients of the sandbox participants. So that's that's kind of a thumbnail of the recommendation that we made around this risk assessment process piece. I guess I should stop and ask if there are any questions about that before we go on to the enforcement, which is kind of the reactive side of regulation.
Mary, I thought that was a very useful summary of a very important piece of our work, but I have a question for you that asks basically, what is the relationship between, I read the 1124 memo last night in preparation for this meeting, and I noticed that the last of the recommendations that we went over before the break, item number 16, basically says the regulatory tools from the November 24th memorandum as amended are something that we, as an entire CTJG, agreed to recommend. So I'm wondering if you could share some insight about what is the difference between what we already agreed to adopt in regulatory tools, referring to that memo, and the things that we hadn't yet decided or that you still think need a fair amount of discussion.
Yeah, that's a good point.
It may just be that at a high level, we said, yes, we want to do the kind of thing that's in the 1124 memo, but the details remain to be worked out. Is that it, or is there some other difference between what we've already decided and what we haven't decided?
That's a really good point, and I do not specifically recall, and thank you for pointing that out.
I think it is as you described, Justice Tucker, that we were talking about some specific things like the risk assessment that Mary walked through. I don't think we ever actually voted on what the actual elements of the risk assessment would be. We were starting to have that more detailed conversation, but we didn't vote on that. So I think some of the things, these recommendations D through G, are more specific to the types of information that would be collected, the way that the risk assessment would work. And the tools were just kind of more a general list of things that demonstrate what proactive regulation would be like, or how a risk-based regulator would operate and what types of tools they would use, but not the level of detail that Mary was describing.
That's correct, Bridget.
And I'll note that, and that's, it's a really good question, because the way it's framed, the issue that the way that's framed in the memo that we had for the working group, proactive regulation tools is sort of the title that's imposed on all of these things that I've just talked about. Whereas the memo that we worked on through SAGE, we actually broke out proactive regulation tools as just kind of a list of specific, mechanisms. So it was much less detailed. So that's why I just, and I guess from Bridget, from what you're saying, and Mimi, what we voted on was more, let's include for consideration for the regulator all of these tools that we've identified, but not necessarily more detail with regard to how they would be implemented. Is that right?
I think that's correct. And then there was parts of the appendices that we had created that we were going to flush out or create as a separate item. So that wasn't voted on initially as well. So.
Okay, because I don't think that the risk assessment table was voted on. And I think, and I don't think we believed at Sage necessarily that we had completed our work on that.
That all makes sense. Thank you very much for that clarification.
Okay, so if there are any other questions, I'll jump into enforcement. Okay, so we started to work on enforcement, which again would be the second part of regulation, which would be the reactive side as opposed to the proactive side. So the kind of concepts that we started working with were that the regulator should establish thresholds to be utilized in enforcement, which correlate to the recommended consequences to an individual provider according to the evidence of harm, meaning what are the consequences to sandbox participants if they cause particular types of consumer harm. And then once that's defined, then then we could figure out, the regulator can figure out what kind of discipline measures might be useful. And obviously from the state bar context, we're very familiar with various, very highly regulated forms of discipline, from a warning all the way up to disbarment, so that we can use that potentially as a model for this regulator. We also on the table to be considered, but we really didn't get very far with this. We're considering other types of programs which could be utilized to provide protection for consumers, including at some type of mandatory fee arbitration, such as parallel to what we have for attorneys in the Mandatory Fee Arbitration Act, and also the Client Security Fund, which is a program that the State Bar has, which provides reimbursement to consumers in certain instances who've been harmed by their attorneys. Perhaps there could be some parallel fund set up to reimburse consumers who experience harm from a sandbox participant. And that's it. Any questions on that? Okay, great. Is Justice Tucker back? It looked, Micah, like she was with you and then she left.
Yeah, she, I think, is back in her conference room and hopefully able to access the internet in a way that's productive, but we might see her back blurry again in my room.
Okay. Well, then maybe if there's no questions, why don't we just go right into the scope of a regulatory sandbox, and that's Becky.
Thanks, Mary.
I'm sorry. I see Justice Tucker there, but were you trying to talk and are we not hearing you? Oh, gosh. Sorry. Keep going. Okay.
Sorry, just real quick, Justice Tucker, you might want to call in on your cell phone if your computer's not giving you any.
And we'll make sure, we'll send IT down to you again to help you.
Should we take a break so she can kind of figure out what's happening here? I hate the chair of our meeting isn't able to participate because she's unable to connect to the internet appropriately.
We don't need to take a break. I can hear everything. I just can't talk.
Okay. She says we don't need to take a break and she can hear everything. She just can't talk for now, but I see Tom. Hi, Tom, the IT guy. So I think it'll be fixed.
So if Justice Tucker, maybe you could communicate through Micah. Is it okay if we go on and have Becky present on the scope of a regulatory sandbox?
Yes.
Thank you, Micah.
Okay, great. Thanks, everybody. So the scope committee was was charged with developing some recommendations about the scope, so what's in and what's out of the sandbox. And this set of recommendations summarizes where our conversation was at the time when we pressed pause. So the idea of the sandbox is that it's open to two kinds of practice that would violate the current rules about who can make money or invest in the practice of law and who can engage in the practice of law. So the sandbox would be open to non-traditional business models, which might include non-lawyer ownership, non-lawyer investment, the kinds of things that would violate Rule 5.4. And then also things that would violate the current provisions against the unauthorized practice of law, whether those were legal practice by people who might not be licensed attorneys, or by computer programs that might be doing very fancy things, but were not themselves licensed attorneys. So that was the first sort of place where our thinking landed at that point. And then, one of the purposes of the sandbox is to expand access to justice. And the group spent a lot of time thinking about ways to incentivize the entry into the sandbox of entities that would do things that serve currently underserved populations. And so part of their thinking, or our thinking, was that we should offer carrots. So if someone comes to the sandbox and proposes something that they can credibly demonstrate looks like it will predominantly serve low and moderate income people, they'll be sort of fast tracked for review. They'll be prioritized for assessment and authorization. And then if they also make that same credible demonstration that principally they're going to be serving people who are currently underserved, so low and moderate income Californians, they wouldn't have to pay the application fee. So you're trying to open the door as wide and make it as easy for access to justice focused organizations to enter the sandbox as you can. For for all entities in the sandbox, they're going to pay a fee to be regulated. And that fee is based on a tiered schedule that reflects their revenues. So nonprofits are going to pay lower fees than big fancy for-profit organizations. The rest of the scope conditions reflect the incorporation of decisions that the group made in the things we discussed earlier. So disbarred, suspended, etc. lawyers can't participate in sandbox entities, so the applications that include them will not be considered. You can't use the sandbox to get around the fact that if you're going to be a licensed attorney practicing law in the state of California, you need to be a California licensed attorney, right? So you can't use the sandbox to get around the state practice rules. Then there are another couple of recommendations that reflect the idea that when lawyers are in the sandbox, unless there's a special exemption for specific lawyers, they have to act like lawyers, right? So they have the same responsibilities under the rules of professional conduct as they would if they were practicing in traditional law firms. And then the final thing that group was talking about was recommending that, and this, I think the scope group was unanimous in this, that any entity in the sandbox must maintain a statutory agent inside the state. So that's where we came down back when we pressed pause before the summer started. I don't know if folks have any questions about that.
I have one. And maybe I misheard you. I apologize. When you were referencing, did you say that they have to be licensed in the state of California?
No, but if let's say I'm a licensed lawyer in Nevada, I can't open a sandbox entity so that I can practice law as a Nevada licensed lawyer in California.
Got it. But if you're a Nevada lawyer living in California, well, that wouldn't make you a Nevada lawyer. I'm just thinking about all the people who live here who have federal practices. So they may not have a license. They might got their license when they, were in New York, but they're doing their federal practice out here. They're not exempt.
I'm gonna rely upon lawyers.
If they're allowed to practice in California, whatever it is they're practicing, they'd be allowed to do that kind of sandbox in California.
Yes,
yeah.
If they're lawyers, yeah.
Right, got it. Thank you.
Micah, did you have a question or comment?
I do. One clarification and then a question. You said that the fee will be based on revenue. What if we have a brand new entity that wants to kind of figure things out in the sandbox? Their plan is to be for profit, but how is the sliding scale going to be applied in situations like that? Is it a certain price if you're an S corp or an LLC and another price if you're a 501c3, or do you literally look at projected revenue and decide what their entry fee is based on that?
So I think that's a great question. I don't think that we had worked out all of those details. If someone remembers more clearly than me, I would welcome them to jump in. But as this is phrased, they're going to pay twice a year, essentially dues to be in the sandbox that are based on data we have about how much money they actually have made. That's the way it's currently framed. But
have made as participants. So
yes, during the previous 6 months. So in the previous 6 months, you made X. Then if you're in tier 1, you're going to pay Y% of X. If you're in tier 2, you're going to pay Z% of X. But those tiers haven't been, to my knowledge, or to my memory, I should say, we haven't decided on what the tiers are. We're just proposing a tiered structure.
Okay. And then my second question is this, and I can already feel it's not going to be super articulate. So bear with me. But if we have, for example, an Arizona lawyer who is also licensed in California, but working in Arizona and part of an entity that now can do business in Arizona as an alternative business structure, if that business, if there's scope creep into California, is that lawyer potentially exposed to, unless they're in the sandbox here, exposed to discipline, because what they might be doing is, violating 5.4 or whatever other rule, but it's copacetic in Arizona?
So I think that raises a really interesting question about reciprocity. And this group hasn't really gotten to that issue yet, right? That we would recognize practices that were authorized in other kinds of, in other states and similar kind, in the Utah sandbox, for example. I don't think we've discussed that at all.
Because there's some evidence out there that's happening already with PI firms, for example, in Arizona, or businesses related to the PI practice. So, okay, so you're saying we haven't figured that out, but that would be part of what we would do with respect to this agenda item, which I can't see right now, right?
Yes, that would have to be a consideration, I think.
Yeah, I'm not sure reciprocity is the issue, that they would still have to go through the sandbox admission process before they could practice here.
Micah?
Before they could do something like share fees, right, Kevin? Is that what you're saying?
Yeah.
Okay. Thanks.
Can anybody hear me?
Yes.
Oh, perfect. Micah, can you tell us a little bit more about what you dropped that little line? There's some evidence already that people who are ABSs in Arizona are active in California. Can you tell us a little more about that?
I mean, I'd rather, yes, I can tell you what I know, but I can gather more information because, obviously there are people in Arizona watching what we're doing, and people here who are licensed in Arizona watching what, is allowed in Arizona. And my understanding is there are entities based in Arizona who can engage in certain behavior because of the rules as they exist in Arizona, and that they're trying to figure out how to start doing the business in the way that Arizona allows it here in California. So obviously I'm not going to name names just yet or provide that kind of detail, but I'm happy to go back and information gather, because obviously this is a concern.
Well, we can follow up offline, but that'd be great. Are there other comments or questions for Becky or in this area of the work we were previously doing? Well, maybe Becky should march right on to the next topic.
That was all the topics, Justice Tucker.
Oh, we got to the very end. All right. Well, then let's take a few minutes to talk about what the outstanding issues are that aren't yet reduced to things we were talking about, but that strike people as really important. I don't think it was on this list, and if it was, but I was out of the meeting temporarily through no fault of my own during that moment, please forgive me. One of the issues that's on my radar, for example, is what role will or must a California licensed attorney play in a sandbox entity? Is there going to be a requirement, and if so, what sort of a requirement? That seems to me like an important scope-related issue that we need to discuss in coming meetings. Marta has her hand raised. She may have, no? Marta used to have her hand raised and doesn't mean for it still to be.
Correct.
Okay, well then other people, please jump in with my beginning of a brainstorming for what some of the questions are that, Mary.
So I guess one thing that we've circled around a couple times today, and of course spent some time, again, sort of circling around before, but not really, I think, necessarily directly addressing, although I could perhaps be wrong on that. We clearly do have to spend some time talking about what rules and or statutes currently applicable to the practice of law in California would be subject to being relaxed, or waived by the regulator. I don't think that's a threshold conversation. I think we need to work on particularly the consumer protection mechanism, so that we have a sense of what this operational environment is going to be before we discuss that. But I do think that's going to be something that we're going to have to get to sooner than later, but again, not first on our agenda.
Thank you. Lori, Justice Dillon.
Yeah, and I apologize if this is something that has been discussed before and I just kind of missed the fact that it was, but in doing this and looking at the evaluation, is there a way that we can look at the impact of these new proposals or these new working environments on existing services that are now available? For example, some time ago when England first started doing alternative business practices, there was an early report that came out that said it directly and negatively impacted the willingness of lawyers to do pro bono work. And I don't know if there was ever a follow-up study on that or whether that ever held, but I guess that raises a question in my mind of, can we, and maybe Becky knows this better than anybody else, but is there a way to look at this and make sure that we are not displacing things that work well now by putting in these new systems?
So it sounds like you're talking about doing appropriate data gathering and research once the project is launched, or are you talking about something that would be done beforehand in deciding whether or what kind of project to launch?
I think in a way, and not to be too difficult, but I think in a way both. That to the extent there is information out there about the impact of these kinds of alternative arrangements on traditional service delivery, we should know about that. But then going forward, items that are approved for the sandbox part of the evaluation should also include that if it's possible to do it.
Got it. Thank you very much. Eric.
I actually had one that I think builds on what Judge Zilon just said, which is I wonder if we should think about including a list of reports we would like the sandbox regulator to make at some point in the future. You know, and these need not be requirements, but just recommendations for things that, you know, we may not have the data to deal with now, but questions that would be helpful, you know, when trying to decide how to evaluate this experiment. And I just wondered about that one. And then the second one was, I had not thought about this till this exact moment, but Micah brought up an interesting question of reciprocity and how do we want the regulator to think about that? I think personally, off the top of my head, I would say I don't like the idea of reciprocity. These are individual experiments and they have different approaches, but we might want to give some thought to say how data would be used from Utah or Arizona in an application and how we want to view that. I know this comes up a lot in sort of other experimental settings where, you know, how do we want the regulator to think about these when someone may have been operating somewhere else? Does that give us more confidence? Would we want them to use that data? I would think we would, but is that a little fraught? So I don't have any thoughts. It's just that when Micah brought that up, I thought it was something I had not thought about at all, that there are other experiments running and there may be information to be gathered there. So those were my two.
Well, thank you. An impartial answer to what Eric said and to what Justice Zeland said. I think we have said already in one of the memos, you know, from months ago, and no doubt could stand to refine the idea that the sandbox experiment must and should include independent outside evaluation, not just of how sandbox participants are faring, but how we may have phrased it, how are other lawyers affected, but clearly consumers, lawyers as service providers, and so on, who are not in the sandbox. So definitely good points there. Marta.
Thank you. Has the state bar ever studied or looked at mandating that its license holders perform so many hours of pro bono services? And if so, when was that and what were the results? It looks like Betty Williams is shaking her head. Maybe that's true.
I just recall that being something that was discussed as recently as last year, I want to say.
There was a proposal
There's
a couple of years.
Good, you're Leah. I was going to say, Leah would know.
Yeah, there was a proposal. I can't quite remember what year, and I believe it was 50 hours a year. And there was a lot of objection to that proposal from both practitioners themselves, but also some of the organizations that thought that they would, realize some of the brunt of having to manage and support that pro bono activity. So it did not advance, but we can certainly dig that up and provide it to the group.
The topic of so-called mandatory pro bono has been kicking around for at least 25 years, maybe longer. New York State ultimately took the position where it was almost quasi-mandatory, but there's a lot here going back many, many years. Toby Loy, many others have been involved in these discussions for quite some time, but there's a rich and controversial history here for if we're really going to want to dig into that one.
I think it would be interesting if that information could be, or maybe the most recent stuff could be dug up. And you said Toby's been involved in that?
Toby's on mute. I don't know whether he'll fess up.
Yeah. Dan is right. This is an issue that comes up every 2 or 3 years, sometimes through the bar, sometimes legislatively. I think about 3 or 4 years ago, there was some legislative efforts, but it has never gone anywhere in California. As Dan mentioned, the New York experiment, there's like 1 or 2 counties in Florida, I think, that had a mandatory pro bono to be a member of their local bar. I haven't heard from that for a long time. I don't know what's happening with it. But I think the area that has been more productive in some areas, at least, is not mandatory pro bono, but mandatory pro bono reporting. that you don't have to do pro bono, but you have to tell us as part of your licensing every year how much pro bono you did. And the theory is, I guess, that the shame factor, if your answer is 0, but nothing, I don't know of any major efforts nationally even to have a major mandatory pro bono program that's gotten anywhere.
Thank you, Toby.
Let me just mention, and our Rules Revision Commission folks will remember this, that although the Rules Revision Commission did not take on mandatory pro bono, the concept of pro bono as a professional responsibility, although not a disciplinary rule per se, did come to fruition in a new comment 5 to Rule 1.0, the purpose and function of the rules of professional conduct. And it specifically provides that there is a responsibility and that every lawyer should aspire to render at least 50 hours of pro bono legal services each year. And that lawyers should also be considering providing financial support to organizations providing free legal services, citing Business and Professions Code Section 6073. So it is not mandatory pro bono, but it is clarifying that since the rules talk about professional responsibilities, it is a responsibility as an officer of the legal system in California to aspire to do that work.
Thank you. What are some other issues or decisions or scope questions that people are really thinking about and concerned with and want to make sure we get talking about?
Justice Sucre, one that did come up in some of the discussions was the concept of the exit from the sandbox. And that was a big TBD issue in terms of, and that's also related to the topic of the term of the sandbox, how many years it should run in order to collect appropriate data to inform what might be more permanent changes in rules governing the profession. And so term of the sandbox, exiting the sandbox, I think is one of our big ticket issues on the TBD list.
That's a good one. Yeah, thank you for reminding us. Other issues that people are thinking about? Marta, your question early on suggested you might be thinking about scope limitations. I don't want to put you on the spot, but I don't know whether by commenting on the paraprofessionals group you meant to draw a parallel to what we should be thinking about, or the opposite of that?
Well, I think parallels may be appropriate. I know we've had several comments in our past discussions that in certain aspects, personal injury, for example, there isn't necessarily a justice gap. And I know the paraprofessional program was limited in family law and UD actions, if I recall correctly. So I was curious as to whether or not we would likewise limit the scope, limit the sandbox participants to particular areas of problems that consumers face, and in our discussions of the development of the sandbox.
So you probably remember that there were two somewhat different views of questions that involved narrowing the scope of the sandbox, really sort of any kind of narrowing. One was the view that innovation, think of the iPhone, starts with small segments of early adopters and then spreads, and therefore we should not try to target the sandbox because we want innovation anywhere with the idea that it will then spread. That was one view. And then another view was, well, if you want to make sure that innovation is targeted at the justice gap, you need to do something to target it. And the do something part was, we did a fair amount of going around that, and comments Becky made in reporting our earlier decisions and discussions. You know, we did come up with, well, we could have you jump to the front of the line in getting your project reviewed for approval for the sandbox, or you get a fee waiver if you're really targeted at justice gap needs. Somebody had at one point suggested maybe we could encourage the legislature to have a grant program for people who are targeted at justice gap needs. Or maybe, as your comment suggests, Marta, we just have rules that say the sandbox is only open to people who are more narrowly targeted at the justice gap. And I think that there may be different views in our committee about the value of doing any targeting, or on the one hand, or being as open to any innovation as possible on the other hand. And so when you ask the question, are we going to limit it only to certain areas? I certainly can't answer that because I don't know what the group will decide. But if you are interested in making in suggesting something, by all means, you should.
Well, I think it would be important when we're listening to the presentation by Justice Petrou about the paraprofessional program, and I know that they also started from a broad base and ultimately only decided to limit the paraprofessionals' work in certain areas. I think that would be important for us to be listening for and to determine whether or not, as we march forward in our further work, how we want to frame Sandbox and the applicants that apply to it.
Got it. Okay, so that's a very good sort of on our list of issues to be thinking about and discussing soon. That's whether to limit the scope of the issue areas where Sandbox entrants would be able to practice would be an issue that we should not lose sight of. I'm going to ask for any more comments or questions about the work to come. And if there aren't any, then I think we're going to take a longer than usual break until our 4 p.m. presentation. Okay, seeing no hands raised, we'll take a longer than usual break and we'll see you all at 4 p.m. Thank you.
You're good to go.
Thank you. All right, we're back in session. Looks like we're not all back in session yet. Do we still have a quorum? My goodness. Oh, I'm sorry. I'm only looking at one of our screens.
We only
Good.
need a quorum at the beginning of the meeting.
Good. Well, plus there were many more people who I could see than I could see on my screen. Super. Well, welcome back, everyone. I am looking forward to hearing what Leah Wilson and my friend Ioana Petrou have to report on the Paraprofessional Working Group. Leah, as you all know, is the Executive Director of the State Bar. Justice Petrou is my neighbor and colleague on the First District Court of Appeal, Division 3. Before that, she was an Alameda County Superior Court judge, and before that, a lawyer. And she has been the chair of the Paraprofessional Work Group. And so we are looking forward to hearing an update on how you all crossed the finish line, because we got a report, gosh, it must be about 8-9 months ago, when you were still in a fairly early stage. And I recognize that your effort is in many ways quite different from ours, but there may still be some lessons we can learn from and some things you have done that we should take account of as we decide how we want to go forward with our rather different effort to challenge some of the same problems that consumers in California face trying to get affordable legal services. So I'm not sure how the two of you are going to split the time, but
yeah,
go
I
ahead.
don't think we're so much splitting as both talking while hopefully not talking over each other. We have a PowerPoint that we put together. And one thing that I want to say at the outset is we tried to put something together to give an overview of where we are and where we're moving forward. But I'm not positive that this best serves your interests or what you want to hear from us. So I really would encourage any of you, Justice Chuka or anyone else, to just pipe up if you have a question during the course of this. With the PowerPoint being up, I certainly can't see everyone who's participating in the meeting. So I'm not going to see a raised hand, whether it's live or virtual, and I'm going to take zero offense and would welcome the just chiming in question, because I think we're here, I'll speak for myself, I'm certainly here to answer whatever it is whatever you'd like for me to answer. And I'm happy to go through some of these slides very quickly in order to do that. Okay, so with that, as Justice Chuka mentioned, I've been chairing this group. I started chairing it towards the end of 2020. Yeah, I guess we're in the middle of 2022 already. So towards the end of 2020, about 18 months ago. Just very briefly what our charter was, and I'm not going to spend much time on this, but I'll tell you why I raise it. So we were charged with developing recommendations for the creation of a paraprofessional program to increase access to legal services. The reason that I put the charter up here at all is that we were not tasked with determining should we have a paraprofessional program in the state of California. Certainly considerations that go into it, such as what is going on in the legal aid sphere, what is going on with pro bono, are there other ways to address these issues? How severe is the need, including amongst people who are many times, many multiples above the federal poverty level? These were all things that came up, but that we didn't spend certainly the majority or a great chunk of our time deciding, because we would regularly come back to our charter, which was we need to put together what we think is the best program and present that to the state bar. Next slide, please. Briefly, how we got here, the working group was established back in April of 2020. I came on later that year. There were a lot of meetings, in particular from late 2020 through the end of 2021. We had about, close to 20 just during that year, full day working group meetings, over 100 subcommittee meetings. And it was in the fall of 2021 in September that we went to the State Bar Board and our initial proposal was sent out for public comment. And we sent it out for an extended period of public comment, in part because it was going to be hitting over certain holidays and we knew that there would be a lot of interest. So there was a general feeling, which I think was very well taken, that there'd be more than enough time out there for people and organizations to review this and to comment. And as we'll see, we did wind up getting well over 2,000 comments. With that, we met a couple of more times this spring. We modified our program in a way that will explain to you what our modifications were. And then we went back to the State Bar Board recently, and that went fine. And my understanding is that it's now in their hands, and they'll be submitting hopefully the proposal to the Supreme Court this summer, and then move it forward to the legislature if the Supreme Court authorizes. Leah, do you have anything else, just very high level?
Yeah, I would just add that before we submit the proposal to the Supreme Court, the board will take formal action. So there will be a public vetting of the exact proposal before it is submitted to the Supreme Court.
Okay, so as I mentioned, we had over 2,000 comments and they were submitted by approximately 1,300 commenters. Certainly, I don't know if this is the most ever, but it's got to be up there. and perhaps, and I see Leah nodding her head, so it may well have been the most hotly commented on proposal so far. I think that your group will benefit by the fact that we went through this already. I don't need to take the time today, but I'm sure that when you get to the point of putting together a proposal and having it go out for public comment, the format in which you do that will be informed by how this happened. We went through some different iterations, and hindsight being 2020 would have prepared some of our forms differently in order to better capture who exactly was commenting, what capacity they were commenting in. So there was a lot of work that was done on the tail end to try to divvy out the kind of buckets of commentators. And we were able to do so by categorizing people as attorneys, non-attorneys, by looking, Leah, correct me if I'm wrong, it was primarily through state bar websites, is that correct?
Yes, state bar, public records and other state bar records, publicly available records.
And we did see kind of a breakdown. Now, we're not going to call it a split, but a different skew depending on whether we're talking about attorney commenters or not. These are gross numbers. They, of course, don't represent the views of any individual attorney or group. But as you can see, that when we looked at just the attorneys, they were generally opposed to the ideas. Non-attorneys were generally supportive, and of the unknown, it was around a 60%. So I don't really know what to say about that one versus beyond it being somewhere in the middle.
And I think this would be a good time for me to respond to, I think, one of the, a portion of Micah's earlier comment and question, and it's to say this, that in issuing the recommendations for public comment, as Justice Petrou noted, there were a couple of different iterations. It really wasn't, I don't think in hindsight, the optimal process. What we were attempting to do is to solicit what I would call true public comment. The State Bar really historically has received comment from lawyers, but we are a public protection agency or a consumer protection agency, and we are here to serve the public. So I think increasingly we've understood that mandate to mean that we need to try to hear from the public. And so in trying to hear from the public, part of the challenge is engaging the public, having them be interested in what the State Bar is doing and presenting it in a way that is digestible. And so I think perhaps Michael was referring to one iteration of our attempt to solicit public comment that did, I think it's fair to say that it was supportive generally of the idea of creating a new class of licensee, drawing the parallel to the healthcare field and nurse practitioners, physicians assistants, and doctors. And so I think that, and moving forward as an organization, we do need to systematize and create a standard for public comment that has a foundational principle of being having the process be accessible and digestible by the public, and that getting real public comment is important, and doing so in a way that is not intended, designed to, or have the effect of swaying the public. And so that will be an important consideration, I think, for your process that you're undertaking and now. And I can acknowledge we didn't necessarily do it perfectly for the paraprofessional program. One more slide on public comment. This is the organizational response.
Do you want to summarize that for us, Leah?
Sure. Here we just said, so you saw in the previous slide, we got comments from individuals, and then we also had comments submitted on behalf of organizations, about 100 organizations, 74% of which indicated opposition. And again, you saw that the majority of the organizational comments were received from what we would either law firms, attorney membership organizations, or legal services programs. And those commenters were opposed to the recommendations. In contrast, academics, consumer advocacy organizations, which were a much smaller percentage of the commenters or commenting organizations, generally supported the recommendations. And so the working group met twice to review the public comment received. So I'll tee this up, and then maybe Justice Petrou, you can go through the actual. So what we're going to go through now are the recommendations. And the reason this slide is presented in kind of a color-coded fashion is that anything you see in this green-blue in the subsequent slides reflects a revision to the original recommendations made pursuant to the public comment process.
Okay, so, and you know, some of this will be somewhat repetitive of what we chatted with you about however many months ago it was at this point. I think that Allison was correct. It was probably about 8 months ago or so. And as Leah noted, so for example, here we don't see any of that blue-green. So these have not changed as a result of the public comment and the meetings thereafter. One thing I do want to say is that in all the, you know, in the full transparency, which I think is very important, when we presented the information to the State Bar Board and in all of the public materials, we're very clear with all the votes that were taken, what the votes were. And so it is clear when one has the underlying documents, what was kind of an overwhelming yes or no versus the couple of more limited areas that were closer. So I'm not going to spend much time on this. We did talk about it before. It was a collateral criminal. Yeah, that's fine. That's fine, Leah. So just briefly, collateral criminal, and the rest is on there. Then moving on to family, children in custody. And sorry, Leah, I thought that there was a change on this one.
You're right. It's in another slide because of the family was so complicated. We had a couple of slides. You'll get to it next, I think.
Okay. So why don't we move ahead to where we can actually see any changes that we made. Okay. And so within the bucket of family, children in custody, which is a very large area, included our dissolution and separation, including support and property division and general custody and visitation. But then there are some specific areas within family that are particularly complex or not well suited to what we think a paraprofessional should be doing. A number of those were already on there, including things like involving the Hague Convention or quadros having to do with the retirement accounts, premarital agreements with all the other considerations that go in there. The one thing that was added, and honestly, I think it was an oversight that it was not included in the first instance, was surrogate parentage actions. And then the other thing that was added was conservatorship and guardianship of the estate as being excluded.
Right, and that was also one that was more of a clarification. So family encompassed not just, divorce and child custody, but also you can see that it included adoption, it included some discussion of dependency action, violence prevention, as well as guardianship and conservatorship. Those were all considered by the paraprofessional working group under the broad header of family, children, and custody. So with respect to conservatorship and guardianship, after the public comment process, we clarified that anything having to do with the estate versus the person is excluded. That was always the intent of the working group, but it wasn't clear. So subsequent to the public comment process, we've clarified that.
And Leah, do you want to go over the licensing one?
Sure. In terms of the licensing requirements, just very briefly, the working group did develop recommendations for who's eligible to seek licensure in the first instance, and you can see that up on the top. And then universal and practice area specific educational requirements. Pursuant to the public comment process, you can see the change there in green, and this has to do with the collateral criminal practice area, specifying that there will be a requirement for those seeking licensure in that area to be trained on the potential immigration consequences for non-citizen clients. There was a lot of debate as to whether or not to exclude representation of non-citizen clients altogether, but where the working group landed was not to exclude these potential clients from getting paraprofessional services, but to require specific training around potential consequences.
And before you go to the next page, just a reminder to folks that the whole concept behind this is that a paraprofessional will be licensed in a specific area. So it is not that one would be licensed as a paraprofessional who could do family and criminal and unlawful detainer and everything else that was listed out there. So that one would be licensed as a paraprofessional for family, able to do these specifically delineated tasks, or for the collateral criminal, or for consumer debt, et cetera. Just a reminder, because sometimes people think it would be, it is different from getting a JD, where you have your JD and you can practice in any area of law, regardless of whether you had a class in that area beforehand, for example.
Right, and you can see that family and children, and as well as housing, have the highest number of unit requirements. So there were no changes here. I don't know if you want to cover.
Yeah,
this
just briefly, there was a lot of discussion about the number of hours required. There's been a lot of debate about whether some program, elsewhere falter because of having the requirements being too high. So again, it's the perpetual balancing act between getting people the help they need, but ensuring that it is quality help, and also allowing a path forward for people, for example, who have JDs but didn't pass the bar, to move forward with their professional careers and not make it so onerous that no one could actually do this. Yeah, go ahead.
These are the regulatory requirements. So just looking at the top, there is a requirement for a bond, not a requirement for malpractice insurance, another kind of hotly debated topic by the group. Requirement to contribute to a dedicated client security fund. And you can see there the change stemming from the public comment process was to require disability-related bias training to be part of the MCLE requirement. Other than that, there weren't any changes here from the original recommendations. And you do see down at the bottom, proactive regulation, a topic that came up during your previous conversations. The concept has been imported into the paraprofessional program with this annual reporting requirement that, of course, does not exist for attorneys today.
Well, and there are other, if you could just stand there for 1 second, this isn't somewhat similar to what is required for the JDs, but different. So for example, and Leah, correct me if I'm wrong, I do not believe that at least currently attorneys are required to get MCLE and trauma-informed practice. Is that correct?
That's correct.
Okay, thank you.
And the total hours required here matches that required for legal specialists, 36 versus the 25 every 3 years for attorneys. I see a hand up. Lucy, do you want to take the question, or you want to go to
the
just
slide? Really quick on the annual reporting requirements. What are they? Is it just the fees, and there wasn't under the bullet there?
Yeah, I can pull that up, but let's go through this and then I'll.
Oh, sure. Okay.
Yeah.
Thank you.
Okay, so this area, whether it should be co-ownership with lawyers, probably got the greatest number of comments back. And it was also one of the very few closer votes in the first instance, if I recall correctly. And so this was, I would say, the most major change as a result of public comment and further meetings of the working group, was a change in this recommendation such that co-ownership with lawyers is not allowed. Leah, what do you want to add on that?
Nothing.
Ownership of what?
Law firms. So paraprofessionals, in the original set of recommendations, paraprofessionals and lawyers could co-own a firm. That was probably the most controversial aspect of the recommendations. After the public comment period, that recommendation was changed.
It has, and this is not different other than the local contact information regarding free or low cost services. There's, as part of the original proposal, a very rigorous disclosure and informed consent with everything that's listed on here, including that the paraprofessional is not a lawyer, exactly what are they licensed to do, that a client can hire a lawyer, that free or low cost services may be available, whether or not they have malpractice insurance, and so on. The only change after the public comment and further meeting was to add that the free or low cost services not only may be available, but to add local contact information with a request from the working group, for lack of a better term, that the state bar maintain this information regarding free or low cost services so that the paraprofessionals have a place to go for it, because there was some concern about how is any one person supposed to make sure they're staying up to speed, especially with the fact that not doing so would be a violation of the rule of professional conduct. Leah, was there anything on that?
No, so this was another area that generated a lot of debate, and where we landed, I think, is a good compromise in that the state bar is responsible for maintaining the contact information, not the individual paraprofessional. Do you want me to take this one quickly? Sure. And just a lot of concerns raised during the course of the process about the current prevalence of the unauthorized practice of law, victimization of vulnerable communities, and the concern that creating a new class of non-lawyer licensee would increase the incidence of UPL. So to that end, there was a dedicated focus on UPL and a set of recommendations promulgated around prevention of UPL. And some of those, as you can see, are statutory changes. Some have to do with funding. In the regulatory scheme for paraprofessionals, there are file retention requirements that are beyond those that exist for lawyers. And then there is a public education component, but all designed to address this sort of overarching concern that UPL would increase as a result of introducing a new class of licensee.
You can take this one. Yeah, you can take this.
Yeah, we didn't make changes here. There's a fully articulated discipline system. So again, as you all were talking about proactive regulation and enforcement, there is certainly a traditional enforcement mechanism in the paraprofessional program. What I would call out here is that there is no private discipline contemplated in the paraprofessional paradigm, whereas in the attorney scheme, there is, of course, private discipline. So that's one of the very significant changes. There's also the introduction of citation and fine for the paraprofessional, which does not exist as a disciplinary consequence for lawyers. Do I take government?
There's no major change here as far as the oversight committee. The only thing that was added, or clarification that was added in the latest iteration, was that one of the attorneys, one of the two attorneys who are part of the 13 members, should have experience in the legal service delivery system for low and moderate income Californians. That was really the only change. And this also was,
we already have that.
Sorry?
Sorry. I was just going to say, you'll be glad to know we already have that on our list of suggested members of our board.
Good. So representation in court has not changed. It was brought up again for an additional vote. And again, the working group pretty resoundingly voted to recommend to the state bar that paraprofessionals provide full in-court representation, understanding that they never have any kind of jury trials, and there are limitations, that some of which are listed in here. But the idea is that they can, as a general matter, be in the courtroom, state their client's case, respond to questions from the judge. Anything else on that, Leah?
No.
Okay.
I'll do this one quickly. There are any changes here, but we circulated 3 names for public comment. You can see them in English and in Spanish. We have not done the deep dive into the feedback that we received on the names, although it was not, it wasn't of a significant volume, but these names were selected in partially or in large a large factor for their selection was the Spanish translation in particular, and really, again, wanting to avoid the potential UPL impact or victimization impact of a name that when translated into Spanish in the first instance could suggest that the paraprofessional could do more than they could do.
Do we have a slide in here, Leah, regarding the funding aspect?
We do.
Okay, so go ahead.
All right, so this is the program rollout. The idea is that the program as initially rolled out would be limited to 3 practice areas and limited to the counties that you see there on the right. So I think, Marta, you may have said earlier that ultimately only 2 practice areas were approved. And perhaps I'm thinking that maybe you were thinking about the initial rollout, which is limited to 3 practice areas. But as you could see from the previous slides, there were more practice areas approved for inclusion in the program overall. I'll take this one, and you want to do the funding one?
Sure.
Okay, so the green here, it has to do with how the program will be evaluated, and you can see what was added as a result of the public comment process was that the metrics have to be finalized before this even starts. There's a lot of concern about changing the playing field during the game. The idea was you need to identify well in advance how you are going to measure success. Or that needs to be made clear and be made public before anything starts. So there were a whole host of metrics that were identified. And in developing the proposed metrics, we did look to some work that the National Center for State Courts has done. They have issued sort of a standardized set of metrics for what they're calling alternate legal service providers. They really mean paraprofessionals, with the idea being that all the different states around the country that are in various phases of implementing such a program would use at least some of the same metrics. And you can see the obvious value in that. And so the working group did start with the NCSC's proposed metrics and kind of leveraged or added on from there. But the key goal here is to ensure that all of the measures for success and or failure are transparent and stated upfront before the program even starts.
Okay, we also had a lot of discussion in the more recent meetings regarding funding. There was a proposal that was voted down to exclude funding from specific type of organizations, specifically IT or tech organizations. And there's a lot of discussion about how that could be unwieldy, because what exactly does that mean? Is that related nonprofit arms? How are you going to really police what it means? And so where the working group landed was, rather than trying to dictate in advance appropriate or inappropriate sources of funding, to require that the state bar provide full public disclosure of all entities funding the paraprofessional program on an annual basis, such that there is the transparency, and that if there are concerns after the bars made their decisions, that those concerns can be raised and vetted, and that everyone is aware of what is going on. The other funding piece of it that was very important to the working group is that we do not want to take funding away from monies that would otherwise be used to support the state bar's discipline system in order to implement or maintain the paraprofessional program. So kind of a dual, 2 big things: 1, not wanting to take the money from elsewhere, and 2, wanting it to be clear to the public where the money is coming from.
And then our last slide is just for you to share some of our takeaways.
Yeah, and so, as I mentioned early on, we did keep coming back to what exactly is our charter here. It actually was helpful to us, I think, as a working group, to every once in a while pull it up and read it and get refocused. I will say also, really important to understand we're part of the process. There was some feeling at various times that it felt almost that people felt like whatever we recommended was going to be the end result. And that, of course, is not necessarily true. And so it was helpful to us to have Leah every once in a while remind us of all the steps in the process and where we were and the things that would be happening going forward. As I mentioned earlier, the meeting structures, the adherence to making sure that the voting was counted very clearly and documented throughout. Also, the opportunity for people to put in dissenting opinions in a written format, as well as verbalizing their thoughts. All of that, we held very near and dear throughout the entire process, everyone's ability to be heard and viewpoints to be held, not only in the meetings, but going forward and in a documented way such that the bar and others could come back and look at it. And then, of course, also the responsiveness to the public comment. We certainly didn't implement every suggestion made in public comments, many of which were contradictory to each other, but we took a long and hard look at those, and those are continuing, I'm sure, to be considered. Leo, anything else?
If you wanted to speak to the political viability, that came up quite a bit from various members.
I think that's part of the, what role do we play? Which is not that, I have any interest in being Pollyanna or sticking my head in the sand, but we were really tasked with figuring out what do we think would be the best program for the citizens of California to increase their access to desperately needed resources in these various civil actions and collateral criminal actions. And we did not feel, I'll speak for myself, I didn't feel it was appropriate to not propose something out of a concern that it was not going to be politically viable. That's for others in another role and certainly not part of our charter.
So those are our slides, Justice Tucker. I'll take them down.
And I know we had a 4:30 end and we're given about 20 minutes. So hopefully we did it.
Well, we've passed our 4:30 end, but not by very many minutes. And I do want to give anybody who's still able to stay on the line a chance to ask questions if you all have them. Marta.
I understand there's no fee caps, and I'm kind of troubled by that because how can you provide access to justice? I mean, to people that need it without fee caps involved? That concerns me.
Well, there was a lot of, obviously, not surprising to you, there was a lot of discussion about this. And I can't say exactly. I will say that there's a lot in here about having to disclose the ability to have low and no cost services and how to go about getting those. Very different, I think, from what is required from JDs. And there was a real thought there as well that the market will have an impact here. These are not, it's not that one doesn't have any ability to know what it's going to cost when you go to try to hire an attorney or what it's going to cost if you go to one of the available low cost places. Leah, do you want to add on that?
No, just that the working group considered it in several meetings before it developed its initial set of recommendations. And then as part of the review of public comment, we even brought forward a staff recommendation to consider recommending fee caps, and it was not accepted by the working group. So I think the devil is in the details on fee caps. And when you get into the conversation about how they would be set, there's the philosophical conversation about whether it's appropriate given that there's no fee caps on lawyers and that we live in sort of a market-driven society. And then the practical aspect of the conversation about how would you actually set the fee caps. I think ultimately the working group determined that it's just not viable.
Other questions? Hearing none. I want to thank Justice Petrou and Leah for that rapid fire review of where your project ended up. We look forward to seeing how it carries on now that it's out of your hands, and appreciate the presentation. And to the entire group, thank you for your work and your attention for these last several hours. And I look forward to seeing you at our next meeting, which is on the date in August that Randy gave us earlier in the meeting. Take care. Talk to you later. Bye-bye. Meeting is adjourned.